We are live on YouTube.
Good morning. We are on the record in the matter of Dana Nessel, Attorney General of the State of Michigan, on behalf of the people of the state of Michigan versus Enbridge Energy Limited Partnership, Enbridge Energy Company, Inc., and Enbridge Energy Partners, LP. It's case number 19-474 CE. I will indicate before we have the attorneys put their appearances on the record that we are broadcasting this hearing. This is being conducted by way of video conference, and we are broadcasting through the YouTube application. The video conference is the Zoom application, and the public has been provided information as to how to watch these proceedings through that video conference broadcast. With that, if I could have the attorneys please put your appearance on the record. Mr. Bach, we'll start with you, sir.
Thank you. Good morning, Your Honor. Assistant Attorney General Dan Bach on behalf of the plaintiff, Attorney General Dana Nessel, and the people of the state of Michigan. And I will indicate that with me in the room, though not appearing separately, is Assistant Attorney General Keith Underkoffler.
All right, thank you. Mr. DeRosier.
Yes, hi. Good morning, Your Honor. Philip DeRosier, appearing on behalf of the Enbridge defendants, and I am joined here by my colleague Alice Loughran.
And good morning again to you, Ms. Loughran.
Thank you, Your Honor.
Before we get into the arguments of the parties, I'm going to just indicate a brief overview of why we are here and how we got to the stage of the proceedings for really the benefit of the public, because the attorneys are aware of this, obviously. In December, specifically December 15 of 2021, I think it was, the defendants had removed this case to federal court. On September 11th of 2024, I believe that's the date, after various proceedings in federal court, in the federal courts, it was more than one court that there were proceedings, the case was remanded back to this court. And so at an October 23rd, 2024 status conference that I conducted here with the attorneys, the parties indicated they wanted to file supplemental briefing on the cross motions for summary disposition. A briefing schedule was outlined, set, and has been complied with by the parties, leading to the scheduling of this oral argument. And in addition, there were requests by various parties to file front of the court or amicus briefs. Those requests have been granted as outlined in my December 9th, 2024 order. And I believe those briefs have all been received at this point by not only myself, but by the other parties as well. It is my understanding, and I'll have Mr. DeRosier and Mr. Bach can comment to the extent they wish, but it's my understanding that the parties want to organize the argument in this case in this way, that the defendants, the Enbridge defendants, will argue their motion first and specifically also address the state's response. And then Mr. Bach will argue on behalf of the state, and we'll see where that takes us. But I think that's the general framework that the parties have requested that we proceed. Mr. DeRosier and Mr. Bach, anything you want to add to that, you're welcome to do so.
Nothing from me, Your Honor.
Nothing from me, Your Honor.
All right. Then with that, let's go ahead and get started. Mr. DeRosier, go right ahead, sir.
Thank you, Your Honor. Appreciate the opportunity to be here today. Your Honor, the Attorney General seeks judicial relief never before sought or granted to any state official in the United States, the permanent shutdown of a federally regulated interstate pipeline. And not just any pipeline, but a pipeline that has been operating in the strait safely for over 70 years, on which millions of people rely to fuel their cars and heat their homes, both in this country and in Canada, and on which thousands more rely for solid middle-class jobs. In our prior briefing and at the May 2020 hearing, we addressed in detail how the Attorney General's claims fail under state law. While I plan to briefly recap those arguments, I'd first like to focus on the federal preemption arguments in the party supplemental briefing. As we explain in our briefs, the Attorney General's claims are preempted by federal law on 3 separate grounds, each of which requires dismissal. First, the Preemptive Pipeline Safety Act. Second, the 1977 Transit Pipelines Treaty between the U.S. and Canada. And third, the Federal Foreign Affairs Doctrine. So beginning with the Pipeline Safety Act, Congress has made a considered judgment that an interstate pipeline is not the time or place for 50 separate states to enforce their own environmental safety rules. Instead, Congress enacted the Pipeline Safety Act for the express purpose of providing adequate protection against risks to life and property that are posed by pipeline transportation and pipeline facilities. To accomplish that, Congress put in place a comprehensive scheme to regulate the safety of interstate pipelines, including protecting the environment in particular. Exercising that broad authority, PHMSA, the Pipeline and Hazardous Material Safety Administration, has implemented extensive regulations covering everything from construction and maintenance based on the pipeline's location to shutdowns due to imminent hazards. In fact, while this case was pending, Congress imposed additional protections to prevent anchor strikes in the Great Lakes and other coastal areas. That's Section 60109 of Title 49, which we cite in our briefing. But that provision directs the Secretary of Transportation to identify and prescribe standards in environmentally sensitive areas such as the straits. Paragraph G5 was added to that provision in 2020. It requires pipeline operators, when putting together their integrity management plans for PHMSA, specifically to assess potential impacts by maritime equipment or other vessels, including anchors or any other attached equipment. That provision confirms that Congress considered pipeline safety issues tied to location to be within PHMSA's exclusive jurisdiction after a pipeline's built. And the 2020 amendment confirms that Congress likewise considers impacts by anchor strikes to be within PHMSA's exclusive jurisdiction as well. So under this scheme, once a pipeline like Line 5 is built, only the federal regulators can order a shutdown if there's an imminent hazard. And before PHMSA can do that, it must consult with other federal and state regulators and must consider the impact of the national economy and traditional security, among other things. Despite the Attorney General's assertions, a state is not permitted to bypass this carefully crafted federal scheme by filing suit under state law to shut down an existing pipeline. Federal courts have long recognized that this federal scheme occupies the entire field of pipeline safety by giving exclusive authority to PHMSA, leaving, quote, no room, unquote, for state regulation. That's the ANR pipeline case that we cite in our briefing. The Pipeline Safety Act also includes an express preemption provision. It specifically prohibits states from, quote, adopting or continuing in force safety standards for interstate pipeline facilities or interstate pipeline transportation, unquote. As courts have emphasized, this is a sweeping exercise of express preemption. As a result, the Act precludes states from regulating in any manner whatsoever pipeline safety, and that includes seeking their closure based on perceived safety concerns. So, for example, when the city of Seattle ordered a pipeline to shut down its operations, a pipeline that had exploded a few years later, killing 3 people and causing massive property damages, the Ninth Circuit held that the city's order was preempted. That's the Olympic pipeline case. And when a state utility in Iowa ordered a pipeline to shut down because it had been built years earlier without a required state permit, the Eighth Circuit held that the state's order was likewise preempted. That's the Kinley case. As these courts and other courts have held, it doesn't matter that the state asserts a compelling safety or environmental interest. The Federal Act gives exclusive jurisdiction to the federal regulator over those safety decisions. And for good reason. Pipelines are inherently interstate because they traverse multiple jurisdictions and even the national border. A single state cannot make decisions that directly impact the interests of energy consumers in a region of the country or for another foreign sovereign. To prevent chaos, Congress assigned that role exclusively to the U.S. Secretary of Transportation. Now, to be clear, states and landowners are not without any remedy for a tort that might be caused by a pipeline operator. The Act has an exception for tort liability, allowing recovery of damages arising from pipeline operations. But here, the Attorney General seeks injunctive relief in the form of a permanent shutdown. As the United States explained in its amicus brief in the Bad River case, the tort exception does not save that kind of regulatory type injunction. Otherwise, it would undermine the entire regulatory scheme that Congress intended to be preemptive. In fact, the Supreme Court has interpreted nearly identical language twice and held that the tort exception in those statutes saved only damages, not injunctions. And here that makes sense. The United States alone has 2.6 million miles of pipeline. If every landowner or state official could seek to shut down those operations based on state law claims, it would completely displace the regulatory system that Congress adopted in the Pipeline Safety Act. The Act allows for state agencies and others to bring safety concerns to the attention of PHMSA, so the Attorney General could have gone to PHMSA here, shared the safety concerns she identifies in her complaint, and asked PHMSA to exercise its regulatory authority. However, the Attorney General never availed herself of that opportunity, choosing instead to intrude on PHMSA's role and take matters into her own hands. But the Pipeline Safety Act does not permit that. Now, the Attorney General tries to reframe her complaint to avoid preemption, but those efforts fall short because the entire complaint seeks to regulate pipeline safety. For example, if you just take a look at paragraph 1, it says that this action is brought because of concerns that Line 5 will release oil into the straits. That is quintessential pipeline safety. The rest of the complaint repeats that allegation many times and provides even more detail. Paragraph 51, for example, talks about the principal threats to Line 5's operations, including overpressurization of the pipes, inadequate or improper corrosion control measures, maintenance, and repairs. Paragraph 52 talks about inadequate or improper training. Other paragraphs allege inherent risks of pipeline operation, as well as risks of anchor strikes. These are all safety concerns falling exclusively in PHMSA's jurisdiction. While the Attorney General dresses up these concerns under different state law theories, they all seek a shutdown because of her allegations that the existing operations aren't safe and are at risk of release. Beginning with count 1 of the Attorney General's complaint, the first part of count 1 is the Attorney General's effort to retroactively revoke the 1953 easement under which Line 5 currently operates, 70 years after the fact. She seeks to do that based on a theory that the public trust doctrine requires state agencies granting easements to first determine whether the easement would pose a safety risk to the environment. But the Pipeline Safety Act does not allow states to shut down interstate pipelines based on a state law requirement for review of the safety risk posed by a pipeline. In fact, the Eighth Circuit in the Kinley case rejected a similar argument. There, the Iowa Utility Board, as I mentioned earlier, tried to shut down a pipeline that was built without prior state permit authorization requiring a safety review. In count 1B, the Attorney General alleges that Line 5's continued operation poses a safety risk to the straits and should be enjoined for that reason. Both of these theories are preempted because they seek to continue enforce a state law safety standard, namely that a pipeline cannot be safely operated on the floor of the Straits of Mackinac. The same goes for the Attorney General's count 2, which is her public nuisance claim, and count 3, which is her claim under the Michigan Environmental Protection Act. While those claims are based on different legal theories, once again, they both seek to shut down Line 5 permanently because the Attorney General believes that its current operations are at risk of release in the straits. While the Attorney General argues that her claims are only incidental to pipeline safety, the premise of the Attorney General's entire complaint is that Line 5 should be shut down because it's at risk of release. That isn't an incidental effect on safety at all. It's precisely what the Pipeline Safety Act prohibits. Because each of her asserted grounds for seeking to shut down Line 5 are based on a claim that current operations are at risk of release, they're preempted. Now, the Attorney General raises several arguments in an effort to avoid preemption, but those arguments are all without merit. One of the Attorney General's arguments is that you should apply a presumption against preemption, and that this is the lens through which you should look at the preemption issue. But there's no such presumption when express preemption applies, which is the case here. In addition, all of Enbridge's preemption defenses involve areas that are exclusively federal functions, specifically, like I mentioned, regulating interstate and international pipelines, as well as foreign affairs, which I'll get into in a moment. The Attorney General also argues that the Pipeline Safety Act does not preempt location and routing decisions. But this case isn't about location or routing. The statutory language here is key. It says that the Secretary of Transportation cannot prescribe the locating or routing of a pipeline facility. By using the word prescribe, the statute shows that it's referring only to the initial siting of a new pipeline. Here, the state, not the Secretary of Transportation, already prescribed Line 5's location on the bottomlands when the then Conservation Commission, now the Department of Natural Resources, issued an easement to Enbridge under a statutory authorization. And when the Michigan Public Service Commission, acting under its own separate statutory authority, prescribed Line 5 to be located across the Straits of Mackinac. The Attorney General cites various cases addressing location or routing, but those cases don't involve attempts to shut down existing pipelines. Her lawsuit is simply unprecedented in that regard. Rather, the cases she cites involved attempts to build new facilities. The Attorney General cites no authority to support her claim that the Pipeline Safety Act permits states to revisit their prescribed location decisions once a pipeline is built and operational. Quite to the contrary, courts have recognized that once the location and routing of a pipeline has been established, state and local officials cannot interfere with its operation based on safety concerns. We cite two of those cases in our briefing. One is the Olympic Pipeline case, and the other is the Cowser case. Both of those cases make clear that under the statutory language relating to locating or routing of pipelines, that it only refers to an initial siting of the pipeline. Under the Attorney General's logic, all 50 states would have the authority to shut down existing pipeline operations based on current safety concerns, so long as those concerns are tied to location, even if those operations are necessary to the nation's energy and economic security. But that would create the very problem that led Congress to enact the Pipeline Safety Act in the first place. While the location of a new facility is a matter over which a state can legitimately exercise authority, it's PHMSA that takes location into account once a facility is built, as is the case here. So under the Pipeline Safety Act's 2020 amendments that I mentioned, PHMSA regulations recognize specifically the importance of unusually sensitive locations, and as with Line 5, given its proximity to water and its location in the straits, PHMSA requires more frequent and intensive safety inspections and accounts for the risks of anchor strikes. In short, the location of existing pipelines is a matter that PHMSA is required to and does consider, leaving no room for the Attorney General. Now, next preemption argument I want to discuss is the 1977 Transit Treaty.
Can I ask you a question before you move to that, Mr. DeRocha?
Absolutely.
So with regard to PHMSA accounting for the risk, specifically the risk of anchor strikes, did that only come into being in 2020 when the Section G5 was added to Section 60109?
So, Your Honor, the specific requirements relating particularly to anchor strikes did come into effect in December 2020, but the Pipeline Safety Act has always expansively covered and regulated all manner of pipeline operations when it comes to safety.
But never addressed that specifically.
Didn't specifically mention anchor strikes until then.
Okay. Go ahead, you can continue. Thank you.
Thank you, Your Honor. So, as I mentioned, the 1997 Transit Treaty between the U.S. and Canada is an entirely separate basis for prohibiting the Attorney General's attempt to shut down Line 5 here. That treaty, in short, requires the interrupted flow of hydrocarbons on Line 5. There's no dispute that Line 5 is protected by the treaty, as it was specifically identified in the Senate consent process as one of the protected pipelines. As we discuss in our briefs, the very purpose of the treaty and every article in it shows that the parties did not want a permanent shutdown of transit pipelines once they're built. To that end, Article 2 of the treaty is very broad, provides that no public authority shall institute any measures which are intended to or would have the effect of impeding or interfering in any way with the transmission of hydrocarbons. There's no dispute here that the courts, as well as the Attorney General, are public authorities within the meaning of Article 2. And Article 2 is plainly self-executing, meaning that no implementing legislation is needed. So it has the same force as a federal statute. And under Article 2's express terms, a court cannot permanently shut down the pipeline. Now, as the court knows, Canada formally invoked the treaty's Article 9 dispute resolution provision in October 2021. And that was in response to Michigan's announcement that it was seeking to revoke or terminate Enbridge's 1953 easement. As it correctly argues in its amicus brief, Canada's invocation of this dispute resolution process plainly raises a colorable issue, given that a shutdown of Line 5, as sought by the Attorney General, is directly at odds with the terms of Article 2 of the treaty, which again prevents any public authority from impeding or interfering with the transit pipeline. And that dispute resolution process is ongoing. And of course, we now have a new administration, and there will be a new prime minister in Canada as well. So Canada will now engage with the new administration in an effort to reach a resolution, which could involve international arbitration should those negotiations fail. Now, given those changes, the court may want to see how that process plays out over the next 9 to 12 months, because of course, if there were to be a resolution, this case would be moot. But in the meantime, the Attorney General cannot bypass the Article 9 process. Her only argument in an attempt to do so is she believes that the requested shutdown order is permissible under Article 4. That article authorizes appropriate regulatory authorities having jurisdiction over the pipeline to impose what the treaty calls just and reasonable regulations that are to be applied in the same manner as for any other pipelines. And those regulations are designed to address matters such as pipeline safety and environmental protection. But there are three fundamental problems with the Attorney General's reliance on Article 4. First, as I mentioned, the US and Canada are already in the dispute resolution process. And I'll get into that more in a moment when I address the foreign affairs doctrine. But it's the foreign sovereigns that should resolve any disputes regarding Article 4 and its application, as the treaty contemplates. Second, as the US explained in the amicus brief it filed in the Bad River case, it's PHMSA that's the appropriate regulatory authority when it comes to pipeline safety. It's not individual states, and it's certainly not the Attorney General. Third, we're not talking here about regulations at all, much less just and reasonable regulations that would be applied in the same manner as for any other pipeline subject to PHMSA jurisdiction. The Attorney General here is seeking to enjoin Line 5's operations entirely, which is far outside the scope of any reasonable regulation that Article 4 permits, even if one assumes that Article 4 authorizes the Attorney General to impose such regulations. In fact, if the Attorney General's reading of Article 4 were correct, Article 2's prohibition against the permanent interruption of the flow of hydrocarbons would be entirely meaningless. The bottom line is the United States made a commitment to Canada that public authorities here would not permanently shut down transit pipelines like Line 5. We urge the court to respect the treaty, which is the supreme law of the United States. Because the Attorney General's complaint seeks a permanent shutdown of Line 5, it's barred by Article 2 of the treaty, requiring summary disposition in Enbridge's favor. Alternatively, the court could, as I mentioned, sit tight for a bit, perhaps 9 or 12 months, and let the US and Canadian administrations try to resolve the pending treaty dispute. And since Canada has provided its views here, the court could also consider requesting an amicus brief from the United States, as the Seventh Circuit did in the Bad River case. That would give the court the benefit of both sovereigns' views on the weighty treaty and foreign affairs issues here. But what the court should not do is force a shutdown while the US and Canada are engaged in those treaty negotiations. Finally, the foreign affairs doctrine mandates this result as well. An injunction that stops operation of the pipeline would hamstring the United States in reaching a satisfactory resolution of the dispute that Canada invoked in terms of the treaty. It would impair the treaty's dispute resolution process and impair our government's ability to conduct its foreign relations with Canada. As the US Supreme Court has held, a state action that interferes with the national government's conduct of foreign relations is preempted. That's the Garamendi case that's discussed in the parties' briefs. In making that determination, the question is whether there is more than an incidental conflict. Here, the treaty embodies the United States foreign policy to ensure the uninterrupted operation of cross-border pipelines. It's right in the treaty's preamble. The treaty also establishes, as I mentioned, a process for resolving disputes that may arise. And again, Canada has invoked that process here. As the US explains in its amicus brief in the Bad River case, shutting down the pipeline while that process is ongoing could put it at risk of significant damages if it were to lead to the sorts of harm that Canada describes in the amicus brief that it filed in this case. And it's easy to see how that could amount to billions of dollars. A shutdown could also jeopardize the United States' diplomatic and commercial relationship with Canada. In the United States' own words, the operation of Line 5 has implications for the trade and diplomatic relationship between the two countries, as well as economic and energy supply implications. And the government of Canada, of course, agrees. It made clear in the amicus brief it filed in this very case that a shutdown of Line 5 would have severe impacts on the interests the United States and Canada sought to protect when they entered into the treaty, their shared interest in energy security and economic prosperity. Again, if the court has any question about that, it could always consider requesting the U.S. to file its own brief. Now, in arguing otherwise, the Attorney General once again relies on Article 4 of the treaty. But again, that provision doesn't support a state's ability to permanently shut down an international pipeline. The Attorney General also cites a 1991 presidential permit that was issued to Enbridge for an entirely different pipeline. But as we explain in our response brief, nothing in that permit supports the idea that a state has authority to order that the permanent shutdown of a cross-border pipeline. Because the Attorney General's requested shutdown of Line 5 creates certainly more than an incidental conflict with the United States' expressed foreign policy, it's plainly preempted by the Foreign Affairs Doctrine, providing yet another ground for summary disposition in Enbridge's favor. It's also important to keep in mind that the state of Michigan has already fashioned a more appropriate remedy to the Attorney General's concerns about Line 5. That response does not seek to impermissibly displace PHMSA's administration of interstate pipeline safety law. It respects the Transit Pipelines Treaty, and it doesn't intrude into U.S. foreign affairs. Namely, the state enacted a law in 2018, Act 359, that supports the relocation of Line 5 into a tunnel to be built under the bedrock below the straits. And it entered into an agreement with Enbridge that allows Line 5 to continue operating until that replacement pipeline in the tunnel is operational. Act 359 even created a new state agency, the Mackinac Straits Corridor Authority, to oversee the tunnel process, which it's actively doing. The tunnel, which will be built entirely at Enbridge's expense, is currently in the permitting phase. On the state side of the permitting process, Enbridge has already been granted permits it needs to build the tunnel by Michigan's Department of Environment, Great Lakes, and Energy, and will soon be seeking renewal of those permits. It was also granted the permit it needs from the Michigan Public Service Commission, and together with the MPSC has recently defended that permit in the Court of Appeals. Meanwhile, on the federal side, Enbridge is awaiting the completion of the environmental review and permitting process by the U.S. Army Corps of Engineers, a process that may well be sped up under the new administration. In any event, once it has all of the permits it's required to have in hand, Enbridge has made very clear that tunnel construction will commence without delay. As the government of Canada, of course, mentioned in its amicus brief, it supports the tunnel as the most appropriate solution to the concerns raised by the Attorney General here. And Enbridge is fully committed to the tunnel project, and as well as closing the current pipeline as soon as the new pipeline is operational. In the face of the arguments we've presented and the fact that the state has already agreed to a different result than the Attorney General seeks here, the court should grant summary disposition to Enbridge. Doing so is not only required by the federal preemption of the Attorney General's lawsuit arising from the Pipeline Safety Act, the Transit Treaty, and the Foreign Affairs Doctrine, but it also respects the different path forward that the state has already determined. Your Honor, so that basically covers what I wanted to say about the federal preemption arguments, but I wanted, if it's okay with the court, for purposes of trying to be efficient here, I wanted to just briefly recap our state law arguments as well.
Sure, that's no problem. Let me ask you a question, though, before you do that, Mr. DeRoche. In your reply brief, one of the reply briefs, you indicate that, I just want to make sure I understand this part of your argument. I think I do, but let me give you an opportunity to address this specifically. You state that under the Pipeline Safety Act's preemption clause, there is just one test: whether this suit seeks to impose state safety standards on interstate pipeline facilities. And so my question to you is specifically, what safety standard does Enbridge assert the state is seeking to impose by challenging the validity of the treaty? That portion of it, the challenge to the validity of the treaty. What safety standard is imposed? Because you indicate that's the one test.
Right. Yes, Your Honor. Thank you for that question. So, yeah, it's Enbridge's view that regardless of the claim or regardless of the preemption defense that we're talking about here, the Attorney General's complaint is singularly focused on imposing one ultimate safety standard, which is that no pipeline under any circumstances can safely operate on the bottom of the Straits of Mackinac. And that's why the Attorney General is seeking specifically to permanently shut down Line 5, despite the preemptive effect of the Pipeline Safety Act, despite the treaty's prohibition against shutting down permanently the pipeline. That's the safety standard that, in our view, the Attorney General is seeking to impose here. It's the idea that no pipeline can safely operate on the Straits bottomlands.
Right. Thank you, sir. You can go on to the other parts that you wanted to address.
Thank you, Your Honor. So I'll keep this very brief because, as I mentioned, we did address the state law arguments in our prior briefing, and I do anticipate that we'll be talking a little bit more about this later when the Attorney General presents her argument on her motion. But starting with count 1A of the Attorney General's complaint, this is, as I mentioned, the argument that the 1953 easement is void from its inception. Enbridge has been operating Line 5 since 1953. Pursuant to that easement, which was issued by the Conservation Commission, as I mentioned, under specific authority that the legislature gave it by way of the statutory provision being 1953 Public Act 10, to grant easements over public trust lands for the construction and operation of pipelines. In granting that easement, the Conservation Commission expressly found that that Line 5 would, quote, be of benefit to all the people of the state of Michigan and operate in furtherance of the public welfare, unquote. And we know that to be the case. The complaint itself acknowledges that the Public Service Commission's contemporaneous finding that Line 5 would enhance national defense and trade relations with Canada, and that before Line 5 was built, oil was shipped through the straits on oil tankers, a true threat to the surrounding public trust waters and lands. Yet, according to the Attorney General, Enbridge's easement for Line 5 was somehow void from the time it was issued because the Conservation Commission didn't use certain words that we refer to this concept of certain magic words. I know that the Attorney General doesn't agree with that characterization, but it's the idea that certain words weren't used that the Attorney General says were required by the Illinois Central and Obrecht decisions, even though the Attorney General at the time approved the easement's legal form and effect. Now, the Attorney General offers this argument more than 70 years after the state granted the easement, and despite the fact that not one of her predecessors, or any other Michigan official for that matter, has ever suggested that the easement is somehow invalid. Quite to the contrary, just 6 years ago, Michigan confirmed the validity of that easement when it entered into an agreement with Enbridge, allowing the pipeline to continue operating in the straits until the tunnel project is completed. That agreement, known as the Third Agreement, expressly states that it's in furtherance of the public's interest in the straits. The Attorney General's challenge to the easement's validity is also just wrong for a host of reasons. First, the Michigan Supreme Court was very clear in its decision in the Obrecht case that it wasn't talking about conveyances made under what it referred to as previous legislation. Here, the 1953 statute, which authorized the grant of the easement, is by definition previous legislation because it was enacted 7 years before Obrecht was decided. There's certainly nothing in Obrecht suggesting an intent to retroactively invalidate an easement that was previously granted under that statute. Second, Obrecht was focused on public trust property that is alienated or otherwise conveyed for private use. Those are the words that the Obrecht court used. Here, as the Supreme Court recognized in the Lakehead pipeline case that we cite in our briefs, Enbridge's use of its easement for Line 5 is a public use, precisely as the Obrecht court referred to. And that's just like any other public utility easement. The court also recognized in the Lakehead case that how the pipeline would benefit the people of the state of Michigan. Finally, the findings that the Conservation Commission made easily satisfy any requirement that Obrecht might impose here. Recall that in rejecting the Attorney General's challenge to the tunnel statute, the Michigan Court of Claims also rejected the Attorney General's argument that the state had, quote, surrendered its duties under the public trust doctrine when it granted the 1953 easement. There, the Court of Claims observed that the 1953 easement concluded that the granting of the easement was in accordance with the public trust. Not only that, one of the statutes that Obrecht cited with approval was 1959 Public Act 84, which authorized the conveyance of an easement to construct a bridge. We attached that statute as Exhibit B to our December 2019 reply brief. It contains none of the formulaic findings that the Attorney General says Obrecht requires. So despite the Attorney General's assertions, there's no basis for invalidating the 1953 easement simply because the Conservation Commission didn't use certain words in making its public interest determination. Turning to the Attorney General's count 1B, again, that's the claim that continued operation of line 5 violates the public trust doctrine. As we argue in our briefs, that claim fails because it's subsumed by the Michigan Environmental Protection Act. That act sets forth the applicable standard for determining whether any particular activity poses a sufficient risk of harm to the environment, including public trust property, to warrant issuance of an injunction. Article 4, Section 52 of the Michigan Constitution specifically places protection of the state's air, water, and other natural resources within the legislative sphere. The legislature exercised its authority under that provision by enacting, as I mentioned, the Michigan Environmental Protection Act, or MEPA, which provides for court action by way of an injunction when conduct is, quote, likely to pollute, impair, or destroy the air, water, or other natural resources or the public trust in these resources, unquote. Through MEPA, the legislature, in exercising the authority granted to it by the Constitution, has established a specific framework that speaks directly to the alleged prohibition identified in the Attorney General's complaint. It's that framework that controls here and to which the Attorney General must turn for relief. In our brief, we cited the Supreme Court's decision in the Preserve the Dunes case. And there the court stated, just as we're arguing here, that a court is not empowered to prevent any conduct which does not rise to the level of an environmental risk prescribed by MEPA, unquote. Now, the Attorney General cites the Glass case, but that case did not involve environmental protection claims. Not only that, the only reason the court turned to the common law public trust doctrine at all in that case, which involved determining the right of the public to walk along the beach, was because the applicable statute there, the Submerged Lands Act, didn't address the issue. Here, by contrast, the Attorney General's public trust claim does fall within a specific statute, MEPA. And so that's the framework that applies. Because the Attorney General's public trust doctrine claim has, in the context of this case, been subsumed by MEPA, any right to relief depends on meeting requirements of that statute. She cannot maintain a separate standalone public trust claim. That takes us to the Attorney General's next claim, which is public nuisance. And I'll return to the MEPA standard momentarily, because that's the Attorney General's final claim. But with respect to the public nuisance claim, it's well established under Michigan law that equity will not enjoin an injury which is merely anticipated, nor interfere where an apprehended nuisance is doubtful, contingent, conjectural, or problematical. That's the Faulkner case from the Michigan Supreme Court. As a result, a bare possibility of nuisance or a mere fear or apprehension that injury will result is not enough to enjoin a nuisance. Here, the risk that the Attorney General's complaint posits, whether that be from general pipeline operations or anchor strikes, is inherently speculative. The Attorney General's reliance on the dynamic risk report, which is attached to her complaint, posits a 1 in 60 chance of a line 5 rupture over the next 35 years. That equates to a 1 in 2,000 chance on an annualized basis. That alone shows the purely speculative nature of her claim. And finally, that takes us to the last count in the Attorney General's complaint, and that's the MEPA claim, which fails for that same reason. As I mentioned, MEPA authorizes the Attorney General to seek declaratory and equitable relief where conduct amounting to pollution, impairment, or destruction of the air, water, and other natural resources has, quote, occurred or is likely to occur. In the Preserve the Dunes case, the Supreme Court said that the determinative consideration under that likely to occur standard is whether the conduct will in fact pollute, impair, or destroy a natural resource. The Attorney General's allegations taken at face value are plainly insufficient to meet that standard. So, Your Honor, with that, that's what I wanted to say as far as kind of, like I said, briefly recapping our state law arguments. And so, unless you have any questions, that's all we have to address at the moment.
Thank you, Mr. DeRoche here. Mr. Bach, when you're ready, sir.
Yes, thank you, Your Honor. And Your Honor, I will respond to each of Enbridge's specific arguments shortly, but in order to fully explain why they are incorrect, I need to briefly discuss the controlling law that governs ownership and sovereign authority over the Great Lakes and the lands beneath them. The Great Lakes and their submerged bottomlands are owned and belong not by the state government, but by the people of the state of Michigan. As we've set forth in our briefs, when Michigan joined the Union in 1837, it did so on an equal footing with the original 13 colonies and every prior state, which means that the people of the state acquired title to the navigable waters of the state and the beds beneath them. This ownership based on the equal footing doctrine arises from the U.S. Constitution itself, and these waters and the submerged lands beneath them are held in trust for the people of the state, the owners of those lands and waters, by the state government. The state government has a perpetual duty, a perpetual inalienable duty, to protect and manage those resources for the people's benefit. This duty can never be waived, and the state, including the courts, must always guard against it. In spite of that law, Enbridge has argued that it has the right to pump millions of gallons of oil through an aging pipeline in the heart of the Great Lakes, which has already been struck and damaged by anchors twice in recent years, regardless of whether it has a valid easement to do so, regardless of whether it has the owner's permission, the people of the state's permission to do so, that it is immune from Michigan law, and that the people of the state cannot do anything, cannot even bring a lawsuit to enforce their rights in their lakes and the lands beneath them. These arguments, as we've said in our briefs, are a remarkable affront to the people of the state of Michigan, their rights in the Great Lakes, and Michigan's sovereignty. And they're flatly controverted by the plain language of the federal laws on which Enbridge relies, and also by clear case law. Now, I want to address each of Enbridge's preemption arguments in turn. But before I do, Mr. DeRosier raised a number of sort of preliminary arguments. I want to point out, he said no state official has ever obtained such relief as a shutdown of an international oil pipeline. But in the Bad River Band versus Enbridge case in 2023, the Western District of Wisconsin federal court ordered a shutdown of Line 5 specifically because Enbridge did not have a valid easement to operate and locate Line 5 on a federally recognized Indian tribe's land. And so that wasn't a state official, technically correct, but a federal court has absolutely recently ordered a shutdown of Line 5 for reasons very similar to what the Attorney General alleges here. The Bad River Band argued that Enbridge's easement had expired in that case. Here, the Attorney General argues that Enbridge's easement was never valid because the required findings were not made under the public trust doctrine. But the reasoning is analogous. So the idea that no court has ever shut down Line 5, no government official has ever sought similar relief, simply not true. As to the Pipeline Safety Act, the Pipeline Safety Act expressly preempts states from adopting or carrying forward pipeline safety standards. It does not say anything at all about state property or contract law. It does not preempt state common law remedies. And indeed, it specifically reserves routing and locational decisions to the states. That's in section 60104E. The 1953 easement, and indeed all of the Attorney General's claims, relate specifically to location. Enbridge admits in its first supplemental brief that the 1953 easement was a routing and location decision, but then argues that somehow it then became preempted after it was originally not preempted. They argue that nothing authorizes a state to revisit that decision once it's been made. But the fact is, we've cited in our brief, there's clear authority that when a state purports to convey Great Lakes submerged lands, and it does so without making the required findings, that conveyance was never valid, and the state has a duty to revoke it. That's the Illinois Central case, the Obrecht case, and both in our briefs and in the amicus briefs filed by FLOW, the Sierra Club, and the Great Lakes Business Network, there's ample authority cited that says that the power to revoke is an inherent requirement of the public trust and that it can never be waived. We've also cited two cases from the Fourth Circuit and Sixth Circuit, the Columbia gas cases, that expressly say that matters of property law and contract law are matters of state law. And that's exactly what the Attorney General argues here. The Attorney General does not seek to enforce any pipeline safety standard. Enbridge seeks to broaden the definition of pipeline safety standard. In their briefs, they argue that anything that is a safety concern or anything that relates to environmental protection is a pipeline safety standard under the Pipeline Safety Act. But that is not the case. The Pipeline Safety Act expressly describes what it means by pipeline safety standards at 49 U.S.C. 60102, parentheses A to B. Sorry, that's a lengthy citation. But it says that pipeline safety standards include the design, installation, inspection, emergency plans and procedures, testing, construction, extension, operation, replacement, and maintenance of pipelines. It's clear under the Pipeline Safety Act that a pipeline safety standard is a technical standard referring to the design, operation, and maintenance of a pipeline. And
Excuse me, Mr. Buck. Pardon me, your Zoom broke up for a second. You said it is clear under the Pipeline Safety Act that a pipeline, please continue from there.
Thank you. It is clear under the Pipeline Safety Act that a pipeline safety standard is a technical standard relating to the design, operation, maintenance, or construction of a pipeline. The Attorney General does not seek to enforce any such thing. And we've cited several cases that make clear that the case law cited by Enbridge is distinguishable from the Attorney General's claims here, and that claims similar to the Attorney General's have been allowed to go forward in courts numerous times. So first and foremost, with regard to the definition of a standard, we've cited also an industry treatise in our briefs that describes pipeline safety standards similarly to what I said just now, a technical standard related to the design, operation, maintenance, or construction of a pipeline, also dictionary definitions. And we've cited a number of cases. I think the most instructive is Davis versus Sunoco, which is the Michigan Court of Appeals 2020 case, a case that specifically involved Enbridge and Line 5. And there, the Court of Appeals denied the argument made by Enbridge and other oil companies that public nuisance actions and actions based on Michigan environmental protection statutes are preempted by the Pipeline Safety Act, because the Court of Appeals held that those are generally applicable environmental and property laws that do not specifically target pipeline safety. It is absolutely permissible for governmental authorities, including state and local authorities, to bring actions against pipeline companies related to state laws, as long as the primary concern is not pipeline safety and the impact to pipeline safety is not direct and substantial. Notably, actions such as, or causes of actions such as the public trust doctrine, public nuisance, and the Michigan Environmental Protection Act are not pipeline safety standards. In order for Enbridge's Public Safety Act or Pipeline Safety Act preemption argument to be correct, the court would have to hold that the public trust doctrine is an oil pipeline safety standard. That is plainly not the case. The public trust doctrine is the common law doctrine arising from the U.S. Constitution that says that the people of the state hold title to Great Lakes submerged lands and have the right to use those waters and lands for fishing, swimming, navigation, and other activities related to commerce. That is plainly not a pipeline safety standard, as described in the Pipeline Safety Act. Similarly, the common law of public nuisance, a common law remedy for acts that interfere with property rights common to the general public, not a pipeline safety standard. And the Michigan Environmental Protection Act is not a pipeline safety standard. Walking through each of those, we've cited 3 different cases where courts have rejected the idea that the Pipeline Safety Act preempts nuisance claims. I mentioned the Michigan Court of Appeals decision of Davis versus Sunoco a moment ago. I also mentioned the U.S. Federal Court for the Western District of Wisconsin's case in Bad River Band versus Enbridge. And we also cited the case of Cheverez versus Plains All-American Pipeline Company, all of which rejected arguments that the Pipeline Safety Act preempts nuisance claims. Similarly, we've cited in our briefs, the Pipeline Safety Act contains clauses that preserve tort claims and claims available under the common law. And we've cited 3 different federal court cases where common law claims were preserved. It was held that the Pipeline Safety Act did not preempt them. That was the Abramson case, the Pridemore case, and the Pennsylvania Gas Services case. The key here, the cases cited by Enbridge, which it argues show that actions such as this are preempted, are all clearly distinguishable. In the Olympic Pipeline case, which Enbridge relies on heavily, the city of Seattle threatened to revoke Olympic Pipeline's franchise to locate its pipeline in a specific spot unless Olympic Pipeline agreed to the city's list of, and I quote, pipeline safety demands. In the ANR pipeline case and the Kinley case, states sought to impose state pipeline safety permitting requirements. You had to apply to the state to get a pipeline safety permit. Similarly, in the Cowser case, which Enbridge cites in its briefs, they cited a state setback requirement that directly conflicted with a regulation under PHMSA. There's no such conflict here, and I think this creates a clear test for the court to apply to determine whether the Attorney General's claims are preempted under the Pipeline Safety Act. The court looks at the relief that's requested. If it's an attempt, and I think the court's question a moment ago to Mr. DeRosier was exactly on point. If the Attorney General is attempting to impose a pipeline safety standard, as that term is described in the Pipeline Safety Act, then it would be preempted. If the Attorney General was arguing that Enbridge had to get a pipeline safety permit from the state, or it had to comply with a list of pipeline safety demands, which in those cases included certain testing, certain operational requirements, that would be a pipeline safety standard and it would be preempted. But we've got ample case law that says nuisance claims, common law claims, and claims related to the routing and location of interstate oil pipelines are not preempted unless they attempt to impose a pipeline safety standard. The Attorney General's claims clearly do not do that here. Excuse me, just one moment. I want to consult with my notes. I apologize, Your Honor, just one second.
Okay.
So once again, Your Honor, the Attorney General's claims are clearly not pipeline safety standards as contemplated under the Pipeline Safety Act. I think the Davis versus Sunoco case is directly on point. The Bad River Band case also directly on point. And there's simply no basis to hold that these claims cannot go forward. And I want to point out two quick things from the briefing. Again, Enbridge argues in its briefs, and Mr. DeRosier argued here today, that the 1953 easement contract, which is the subject of count 1A of the Attorney General's complaint, was a routing and location decision, but that such decisions are only not preempted at the time they're initially made, and they are subsequently preempted once they've already been made. There are two glaring problems with that. First of all, there is nothing in the Pipeline Safety Act that gives PHMSA the authority to preempt locational or routing decisions ever, at any point. There is a strong presumption against preemption of state law by federal statutes, as we've set forth in our briefs. We do not need to show an exception to preemption. The opposite is true. The presumption is that Enbridge is subject to state law, and it has to show a federal statute that preempts that state law. The Pipeline Safety Act says nothing about ever preempting routing and location decisions. Second of all, the entire purpose of this lawsuit is to challenge the validity of that conveyance. This is not a new routing and location decision. So even if Enbridge's argument was correct, it would still not apply. This is a lawsuit arguing that that initial routing and location decision was not properly made and therefore was never valid. Therefore, Enbridge never held a valid easement. Excuse me. Also, we've cited some other things in our briefs, but I just want to quickly point out with regard to MEPA. MEPA is not preempted. The AG's MEPA claim, count 2, I believe, is not preempted because MEPA does not impose any standards, let alone any pipeline safety standards. We've cited two cases, Nemeth versus Abbenmarsh from the Michigan Supreme Court and Her Majesty the Queen versus City of Detroit from the Sixth Circuit, which expressly state that MEPA does not impose any specific standard. Rather, it's a common law remedy that allows courts to enjoin the potential pollution, impairment, or destruction of natural resources or the public trust.
Mr. Bach, I beg your pardon. Can you please do that for me again? It's a common law remedy that allows courts to...
I apologize. Sounds like I'm having some internet connectivity problems.
No, that was just too fast.
Okay, sorry. MEPA is a statute that allows courts to fashion injunctive relief to prevent the pollution, impairment, or destruction of natural resources or the public trust in those resources. That is not a pipeline safety standard, and the idea that it is has been rejected by the Michigan Supreme Court and the Sixth Circuit, as we've cited in our briefs. And so we've provided, I think, extensive case law that shows the true test for whether something is a pipeline safety standard under the Pipeline Safety Act. It is clear that the public trust doctrine is not a pipeline safety standard. It is clear that the Attorney General's challenge to the validity of the 1953 easement is a matter of state contract and property law, which is not a pipeline safety standard. It is clear that MEPA and public nuisance are not pipeline safety standards. And the cases cited by Enbridge are all distinguishable in that they involve situations where states or local units of government expressly attempted to impose pipeline safety standards. We've mentioned in our briefs, but I'll just point out, Enbridge argues that the term pipeline safety standard, in its brief, they describe it as all-encompassing and they expand it to say it relates to safety concerns or matters related to environmental protection. But we've also cited several cases where federal courts have expressly said that when you're looking at routing and location decisions, it does not matter if the regulator, the state or local government, is concerned about safety. What matters is if the decision itself is a routing or location decision. That was the Texas Midstream Gas case from the Fifth Circuit, the Washington Gas Light Company case from the Fourth Circuit, and also the Portland Pipeline case. And we've cited, again, Davis versus Sunoco, where the Michigan Court of Appeals held that generally applicable environmental laws that are not targeted at pipeline safety are not pipeline safety standards and are not preempted by the Pipeline Safety Act. I want to briefly discuss the Davis case and Enbridge's treatment of it in its recent supplemental reply from December 23rd. In that brief, Enbridge takes issue with the fact that the Attorney General pointed out that Davis versus Sunoco involved Enbridge as a defendant and concerned Line 5. And Enbridge says in its supplemental reply that that is not true, and that the case involves storage basins which are plainly not regulated under the Pipeline Safety Act. That is not a correct argument. First and foremost, on page 1 of Davis versus Sunoco, in the first paragraph under the heading Basic Facts, the Court of Appeals notes that the case concerns a metering station in Marysville that is operated by Enbridge that accepts oil from Line 5 and which is an oil pipeline facility regulated under the Pipeline Safety Act. Those are the defenses that Enbridge raised in that case. And now it turns around and essentially says, of course, that wasn't regulated by the Pipeline Safety Act. It's a distinguishable case. Well, that's not what Enbridge said at the time. And I need to point that out. Additionally, we've cited the Western District of Wisconsin's decision in Bad River Band versus Enbridge, where the court expressly held that the Bad River Band was not attempting to enforce any pipeline safety standards. And that was it referred to it as the glaring problem with Enbridge's Pipeline Safety Act preemption argument. In that case, the Bad River Band sued Enbridge for trespass on the grounds that it did not have a valid easement because its easement had expired, and also for nuisance. And neither claim was held to be preempted. And the Western District of Wisconsin federal court expressly rejected the idea that that was an attempt to impose pipeline safety standards. So we've got clear authority that safety standard has a specific definition, which is much narrower than the one that Enbridge assigns to it. Enbridge cannot prevail if the Attorney General's claims are not pipeline safety standards. And so Enbridge seeks to stretch that definition. But that simply is not the case. And I'll also note for the court, we've cited this in our supplemental reply, that after the 2010 release of oil from Enbridge's Line 6B, which polluted Michigan's Kalamazoo River and Talmadge Creek, and which the federal government described as the single most expensive inland oil spill in United States history, Enbridge was sued by a number of state, federal, and tribal government authorities for environmental protection claims related to that release. Notably, PHMSA was not among them because PHMSA does not enforce environmental protection statutes. But the authorities that did sue Enbridge included the Michigan Attorney General, the Michigan, at the time it was the Department of Environmental Quality, now it's EGLE, which Mr. DeRosier referenced earlier, 2 different federally recognized Indian tribes, and a host of federal agencies, including the EPA, the Fish and Wildlife Service, and others. The Attorney General actually brought a MEPA claim, just as she does here. And Enbridge voluntarily settled all of those claims and did not raise any preemption defenses. And I think this goes to show specifically that this idea that PHMSA is the only authority, the only governmental authority that regulates releases from transit oil pipelines, interstate or international oil pipelines, is simply not the case. PHMSA is not involved in environmental protection. Yes, when they're working on permitting a pipeline, doing a review of technical pipeline standards, they consider environmental protection. But they don't enforce the public trust doctrine. They don't enforce state or federal environmental statutes when there's a violation. Once again, Enbridge is attempting to expand PHMSA's role and minimize the role of other appropriate governmental authorities in regulating pipelines such as Line 5. Your Honor, if I can pause just one moment to confer with Mr. Underkoffler to make sure I don't leave anything out. I believe that concludes my responses to the Pipeline Safety Act, but I just want to check with co-counsel very quickly.
Sure, I'm going to have you, and maybe you want to include this in your conferring. Just so I understand, when the federal government chooses to address specific safety concerns, and I understand the distinction that is being drawn between concerns and standards, such as anchor strikes, which Mr. DeRozier referenced has been added in section 60109 of Title 49 at G5, I think he said. How do I evaluate that overlap with the safety concerns that are looked at by the state in determining routing and location? Because your argument is in part that the federal government, specifically PHMSA, can't address routing and location. The state can. But then Mr. DeRozier said they look at all of those concerns and have included sensitive environmental areas now with regard to not specifically just routing and location, but impact from a safety perspective. How do those two things dovetail? Because there's some overlap there.
Certainly, Your Honor, and I do want to confer with Mr. Underkoffler, but my initial response would simply be that the statutes that the Attorney General seeks to enforce here are traditional state police power statutes and common law remedies, I should say, such as the public trust doctrine, Michigan's environmental protection statutes such as MEPA, and the common law of public nuisance, which multiple courts have held to not be preempted as long as they do not seek to impose a pipeline safety standard. The Attorney General is not saying that Line 5 can remain in the Straits of Mackinac as long as Enbridge conforms with certain safety requirements. She's saying that this location, which is, locational decisions are expressly reserved to the states, is not a proper location and Line 5 cannot be located there. And she's also saying that the conveyance that purports to authorize Line 5 there with the state as property owner and the people of the state as property owner was not valid. And so any amendment to the Pipeline Safety Act that refers to anchor strikes still does not preempt the Attorney General's authority to enforce state statutes and state common law, as long as she is not attempting to impose a specific pipeline safety standard, which again, the Act describes in significant detail as a technical requirement related to things such as design, operation, testing, and maintenance of pipelines. And that is not what we're doing here. It's important to note that if Enbridge is correct and the Attorney General's case has to be dismissed, that means that federal law allows Enbridge to operate Line 5 on the bottomlands of the Straits of Mackinac without regard for whether it has a valid easement and without regard for whether it's violating or its presence there violates state common law or state environmental protection statutes. But that is not the case. And I'll get into this a little bit later when we talk about the treaty and the foreign affairs doctrine. But it's worth noting that over the years, the federal government has issued multiple presidential permits for transit oil pipelines, including some to Enbridge, which expressly require complying with state and local laws and obtaining any necessary state permits. And so this idea that any regulation of the pipeline by the state all falls within the umbrella of a safety standard and is preempted is simply not the case. And we've got the test that we've cited from Davis versus Sunoco, which is that generally applicable environmental laws and common law actions are not preempted. And Your Honor, if I can accept the court's permission and confer with Mr. Underkoffler
Sure.
very briefly, just 30 seconds.
Go right ahead, Mr. Bach.
Thank you, Your Honor, and I apologize for the brief delay there. I think
No
that
problem.
concludes that concludes my response as to Pipeline Safety Act, and with the court's permission, I'll move on to the treaty.
Go right ahead, Mr. Bach.
Thank you, Your Honor. Your Honor, with regard to the Transit Pipelines Treaty, Enbridge relies heavily on Article 2 and argues that any effort by any state or local authority, or really any authority other than PHMSA, that would result in a shutdown of a transit oil pipeline is preempted by the treaty, because they argue that the treaty embodies a policy of maintaining uninterrupted hydrocarbon flow through transit pipelines at all times. But that is simply not the case. Very similar arguments, indeed the exact same argument, has been considered by two different federal courts who both rejected it, which I'll talk about in a moment. It has also been disagreed with by the United States government in the amicus brief that the Department of Justice filed in the Bad River appeal in the Seventh Circuit. And we've also cited the transnational litigation blog by Professor William Dodge, who's an expert in international law, who addressed it and also disagreed with it. The two cases we refer to, I think, are particularly important, and we've cited these extensively in our briefs, but we have, once again, the Bad River Band versus Enbridge case out of the Western District of Wisconsin, and also the Portland Pipeline case from the federal court for the District of Maine. Now, in Bad River Band, the Wisconsin court, once again, held that the treaty did not preempt a federally recognized Indian tribe from advancing and indeed prevailing on claims for trespass related to the lack of a valid easement and public nuisance. And that court ordered a shutdown of Line 5. There is currently a court order requiring that Line 5 be shut down or rerouted around the band's reservation by June of 2026. And so this idea that the treaty preempts any such claims has been rejected by the only two courts to ever consider it. We also noted the District of Maine decision in Portland Pipeline. There, that court held that the foreign policy embodied in the treaty is one of non-discrimination, is one of applying laws to pipelines the same way they apply to everyone else. And both the Western District of Wisconsin and the District of Maine based these holdings on Article 4 of the treaty, which applies notwithstanding Article 2. Enbridge has pointed out that Article 2 states that governmental authorities cannot take measures that interfere with the flow of hydrocarbons through a transit pipeline. But Article 4 applies notwithstanding Article 2 and says that it preserves the rights of appropriate governmental authorities to enforce non-discriminatory rules, regulations, terms, and requirements. That's exactly what the Attorney General is doing here. And it's what the courts held in Bad River Band and Portland Pipeline. Additionally, in its amicus brief in the Bad River Band case, the Department of Justice addressed the preemptive effect of the treaty and completely disagreed with Enbridge. The Department of Justice argued in its amicus brief that Enbridge was in trespass without a valid easement, and that the trial court had the authority to fashion a remedy for that trespass that it thought was appropriate, including shutdown. The Department of Justice argued only that at the remedy phase of the case, the trial court should have considered whether there'd be any harm to the public that would arise from the treaty. So the idea that the treaty preempts actions such as the one brought by the Attorney General has been considered and expressly rejected by every court to consider it. It's been disagreed with by the Department of Justice in an amicus brief, and it's been disagreed with, as we noted in our briefs, by the leading scholar to consider the issue. And the reason for this is simple. First and foremost, Article 4 preserves actions such as this. Second of all, Enbridge and Canada, in its amicus brief, refer to Article 9, which creates an international dispute resolution process. And they've argued that that should be the remedy for this. Enbridge and Canada have argued that the court, Mr. DeRosier said here today, should sit tight for 9 to 12 months and allow that process to carry out. But there are numerous problems with that argument. First and foremost, as we've cited in our briefs, anytime a court considers a treaty, it first looks to the treaty's plain text. And we've cited examples where the federal government, when it enters a treaty, knows how to limit the ability of domestic courts to consider disputes related to the treaty. It knows how to prescribe specific forums where such disputes can be adjudicated. We've provided examples in our supplemental briefing of cases where the federal government has done exactly that, but it has not done so here. There is nothing in the treaty that says domestic courts lose their ability to adjudicate cases or should refrain from adjudicating cases until the international dispute resolution process plays out. Moreover, Article 9 applies only to the parties to the treaty. It only applies to the United States and Canada, and it applies only to disputes regarding the interpretation and application of the treaty. It says nothing at all about limiting the rights of property owners to enforce their property.
Mr. Bach, I think you might have broken up a little bit. It applies only to disputes regarding the interpretation and application of the treaty.
Thank you. And I apologize. This is state government technology at its finest. My apologies to the court.
Well, it could be on our end. Then it'll be county government technology.
Fair, Your Honor. Thank you. Article 9 applies only to the parties to the treaty, the United States and Canada, and it applies only to disputes between those parties regarding, among other things, the interpretation and application of the treaty. It says nothing at all about limiting the rights of property owners and barring them from enforcing their property rights or enforcing the requirements of state law in court. And it's important for the court to I think, consider that for a moment. If Enbridge is correct, and if Article 9 of the treaty means what Enbridge claims it means, that would mean that an oil pipeline company could build a pipeline across anyone's land in trespass without an easement, and the property owner would be powerless to sue them or do anything about it. Once again, that is a remarkable affront to property rights, and that would apply to private property owners just like sovereign property owners. Enbridge made the same argument in the Bad River Band case. They argued that it didn't matter whether they had a valid easement over the band's reservation, because any action to eject them would be preempted by the treaty. And the Western District of Wisconsin rejected that argument, and the Department of Justice agreed with that decision. It's a fairly breathtaking claim to say that pipeline companies that own international pipelines between the US and Canada are free to trespass with impunity, and the property owner's only remedy would be to, I guess, ask the United States government to initiate international dispute resolution with Canada to ask the pipeline company to stop trespassing. That simply is not contemplated by the treaty. Additionally, this argument that the court should refrain until the dispute resolution process plays out has a number of glaring problems. First and foremost, unless the pipeline is shut down, there would be no violation of the treaty. And so the idea that the court should refrain from deciding whether to issue a decision that would shut down a portion of the pipeline until the dispute is arbitrated or decided through dispute resolution is exactly backward. The dispute resolution, there isn't a dispute to resolve unless a pipeline is shut down. There wouldn't be a violation of the treaty otherwise. And so what we're seeing, Your Honor, is simply a delay tactic. And we've made clear with the court before that we think Enbridge has employed a number of delay tactics in this case just to postpone things. And it would not be appropriate. I think the people of the state of Michigan have a right to have their claims heard in court. The treaty does not preempt those claims. And there would be no basis for the court to simply hold the matter in abeyance until the dispute resolution process plays out that has already been ongoing for over 3 years, and that the parties are not allowed to participate in. So that I think that summarizes the Attorney General's response as it relates to the treaty. Thank you. That brings us next to the Foreign Affairs Doctrine, unless the court has any questions based on those arguments.
You can move on to that, Mr. Bach.
Thank you, Your Honor. With regard to the Foreign Affairs Doctrine, I think it clearly does not preempt the Attorney General's actions for a number of reasons. First and foremost, this is a federal common law doctrine, and as we've set forth in our brief, federal common law only exists in the interstices where there's no direct federal law that governs. Now here we've got a great deal of federal law that makes very clear that Congress, the treaty, and the courts have spoken to this issue in the past. So there's no need for federal common law making. First and foremost, as we've said, the Pipeline Safety Act itself reserves locational decisions and issues related to location to the states. It doesn't preempt anything other than state attempts to impose pipeline safety standards. That is a clear, direct federal law that addresses this issue. Second of all, the treaty under Article 4 expressly allows actions such as this to go forward, and both courts to consider the issue, as well as the United States Department of Justice, have agreed with that. Third, as we've cited in our briefs, and as the main federal court noted in the Portland pipeline case, multiple federal permits, presidential permits for interstate oil pipelines, make clear that oil pipelines have to conform with state and local laws. And so there was no need for federal lawmaking to consider whether the Attorney General's claims might interfere with some foreign policy of the federal government, because the federal government has repeatedly made its policy on this issue known. And we've also cited multiple federal court decisions and the provisions of the Pipeline Safety Act that say common law remedies, tort remedies, and locational decisions are not preempted. And so there's no reason to engage in consideration of the federal common law foreign affairs doctrine at all, where we've got these clear statements of policy that preserves actions such as this one. But even if the court did apply the analysis, it's clear that the foreign affairs doctrine still would not preempt this action for several reasons. First of all, the court would have to determine, as set forth in the Garamendi case and the other cases that we cited in our supplemental briefs, and I would also refer the court once again to the amici brief filed by the environmental organizations FLOW and Sierra Club and the Great Lakes Business Network. The court would first have to find that the Attorney General's claims directly conflict with some federal foreign policy. But as we've cited, the Attorney General's claims comport and are expressly preserved under numerous statements of foreign policy by the federal government, that being the provisions of the Pipeline Safety Act and its savings clauses, the treaty itself, the presidential permits, and the amicus brief filed by the Department of Justice. Then, the court would also have to find, even if it found a direct conflict with some foreign policy, it would also have to find that the case involved matters of uniquely federal concern. That's another requirement of the standard. But we've made clear, and the briefing has made clear, that the public trust doctrine is a matter of, it's enforced by the state. It's not a uniquely federal concern. MEPA certainly is not a uniquely federal concern, nor is the state common law of public nuisance a uniquely federal concern. And even after all of that, the court would have to find that it has a significant negative impact on that foreign policy. And that simply is not the case. In the Portland pipeline case, the District of Maine, as I noted earlier, expressly held that the foreign policy evidenced in the treaty is not one of maintaining uninterrupted flow of hydrocarbons at all times. It's one of applying the laws in a non-discriminatory fashion. And that's what the Attorney General is doing here. She's arguing that Enbridge and Line 5 are subject to state law exactly the same as everyone else, and they do not enjoy a special status that allows them to operate their pipeline on the property, the submerged Great Lakes bottomlands that belongs to the people of the state without a valid easement, and they are not allowed to operate in violation of the common law of public trust doctrine, the common law of public nuisance, or MEPA. And so the foreign affairs doctrine simply does not apply. Unless the court has any questions for me on that, I'll move on and briefly address Enbridge's state law claims.
No question, Mr. Bach.
Thank you. And I had planned to address these in the second portion when we argue the Attorney General's motion, but I'm happy to address them now. First and foremost, I have to take issue with Enbridge's once again relying on the phrase magic words and arguing that the Attorney General's claim is essentially that the right magic words weren't said when the 1953 easement was enacted. We're not talking about magic words here. We're talking about something very significant, which is the right and ownership of the people of the state of Michigan in their Great Lakes and their submerged lake bottomlands that arises from the U.S. Constitution and the equal footing doctrine. This is a significant thing. It is not mere magic words. Under the U.S. Supreme Court's holding in Illinois Central, which was adopted by the Michigan Supreme Court first in 1896 in People versus Silberwood, and reiterated multiple times over the ensuing decades. When you're talking about the state conveying away the people's land, the people's interest in their submerged Great Lakes bottomlands, the state lacks the authority to make any such conveyance unless it makes formal, due findings in recorded form that the people's rights in their land will be protected. That means formal findings that either the proposed conveyance will enhance or improve the public trust, meaning the people's right to use the navigable waters of the lakes and the lands beneath them for certain activities such as fishing, swimming, and navigation, or at a minimum that it will not impair the people's rights in those lands. And as the US Supreme Court and the Michigan Supreme Court have held, when a conveyance of the people's interest in Great Lakes submerged lands is made without those findings, it is not a valid conveyance and it must be revoked. And that conveyance cannot somehow ripen into validity based on the passage of time. And so this is a significant thing. We're talking about the people's rights in the most precious natural resource that Michigan has, the Great Lakes, and rights that arise from the US Constitution. Enbridge argues that the common law public trust doctrine has been, they say, subsumed by MEPA. That is simply not the case. We've cited the 2005 Michigan Supreme Court case of Glass versus Geckel, where the Michigan Supreme Court said three things that are very significant for the court's consideration here. Number one, it said, and I quote, the public trust doctrine is alive and well in Michigan, and it applied the common law public trust doctrine in that case. That was in 2005, 35 years after MEPA was enacted. So the idea that MEPA, I guess it should be probably displaced the common law public trust doctrine, Enbridge said subsumed, that is simply not correct. Second of all, Enbridge argues that it's only the legislature that enforces or protects the public trust. But in Glass versus Geckel, the Michigan Supreme Court expressly said that the Michigan courts are among the sworn guardians of the people's rights in their Great Lakes submerged lands and the Great Lakes, and expressly held that the court has not only the power, but the obligation to protect the people's rights. Third, interestingly, in Glass versus Geckel, and we've cited this, I believe it was in our supplemental response, the Supreme Court pointed out that there are a couple of state statutes that codify portions of the common law public trust doctrine. There's MEPA, as Enbridge said. There's also Part 325, which is the Great Lakes Submerged Lands Act, that governs conveyances, leases, or permits to Great Lakes submerged lands, and it requires the due findings. But in Glass versus Geckel, the Supreme Court said that those statutes do not constitute the full range of the public trust. They only set forth the extent of the public trust that the legislature is invoking in those situations, and that because that is not the full limit of the public trust, and I quote, we turn once again to the common law. In other words, the Michigan Supreme Court has made extremely clear that the common law public trust doctrine still exists. It is enforced by the courts. It is enforced by the Attorney General. Indeed, under MEPA, MEPA provides that the Attorney General or any other person can bring an action to seek an injunctive relief to prevent the pollution, impairment, or destruction of natural resources or the public trust in those resources. And so the idea that it somehow does not exist anymore is simply not the case. Second of all, and I'll be brief because Mr. DeRozier was brief on this, and I believe it's been thoroughly covered in the party's written filings. Enbridge has pointed to a number of other findings that have been made over the years. This conveyance benefited the public welfare. It was an appropriate conveyance for the purposes of condemning, this is the Lakehead case, which was did not involve Great Lakes submerged lands or the public trust at all, but it was an appropriate conveyance as it related to condemnation law. But none of those findings satisfy the requirement of the public trust, which is that specific findings related to the people's rights in the Great Lakes and the Great Lakes submerged lands have to be made. And Enbridge is pointing to other findings that were made that do not address the public trust and do not address Great Lakes bottomlands. And the law is clear from Illinois Central, from Obrecht, and that entire line of cases, that absent those findings, such a conveyance is not valid, and that the state, and we've cited authority to this effect, as have the environmental amici in their amicus brief, the state has a perpetual duty to enforce the people's rights, and that includes the duty to revoke conveyances where they're not properly made. I'll briefly address, Mr. DeRozier referenced the Court of Claims decision, and there, the Court of Claims did say in dicta that the 1953 easement concluded that the conveyance satisfied the requirements of the public trust. But that is A, not accurate. The 1953 easement says nothing about the public trust. And B, that is not only a bit of dicta, but it's particularly unpersuasive dicta because, as we pointed out in our supplemental response, the Court of Claims said in that same passage that that was not an issue before the court. It said that there was not an issue in that case regarding the validity of any conveyance. That case was about the constitutionality of a 2018 public act under Michigan's Constitution's title object clause. And so where the court has expressly said that it was speaking on an issue that was not before it because it hadn't been raised by either party and was not a live controversy in the case, I think that's very significant that this court should not rely on that bit of dicta, but rather should look at the 1953 easement itself and see that it says nothing at all about the public trust doctrine. Moreover, in its supplemental briefing, Enbridge refers to that decision as having been affirmed by the Court of Appeals. And that is correct. The actual issues that were before the Court of Claims were subsequently affirmed by the Court of Appeals. That is, whether that 2018 public act was constitutional. But the Court of Appeals decision says nothing at all about the validity of the 1953 easement. It says nothing at all about the due findings or whether the public trust doctrine was complied with. And so that is particularly unpersuasive, Your Honor. Sorry, I'm just looking, consulting with my notes here. I think at the end of the day, Your Honor, the law is clear that the claims brought forth by the Attorney General are not pipeline safety standards and do not seek to impose pipeline safety standards. They're preserved by the 1977 Transit Pipelines Treaty under Article 4. Article 9 of the treaty does not apply because that's a dispute resolution process between the parties, which does not in any way inhibit the rights of property owners to seek to enforce their rights in court or the court's authority to hear such arguments. The Foreign Affairs Doctrine does not apply for the multiple reasons that we set forth. Oh, and I also briefly need to just quickly address the argument that counts 2 and 3 are impermissibly speculative, which Mr. DeRosier addressed.
Mr. Bach, excuse me.
Oops.
Now, Ms. Warner, you.
I noticed, I saw that it froze. If you can hear this, you broke up when you said the Foreign Affairs Doctrine does not apply for the multiple reasons we set forth. And I also briefly need to just quickly address the argument.
Thank you. The argument that Mr. DeRosier touched on at the end of his presentation, which is that counts 2 and 3 must be dismissed because they're impermissibly speculative. Counts 2 and 3 clearly allege factual disputes which cannot be dismissed at this stage. The Attorney General has pointed to the numerous threats to the environment and the potential violations of Michigan law that are presented by Line 5's location in the Straits of Mackinac. We've cited to the fact that Line 5 was struck by an anchor in 2018 and by an anchor or similar object again in 2020, both of which necessitated temporary shutdowns of the pipeline, and both of which were not detected or prevented by Enbridge. We've cited in the complaint and in our supplemental briefing the Michigan Tech Report and the Dynamic Risk Report, which set forth the fact that anchor strikes or similar impacts are the most significant threat to Line 5 in the Straits of Mackinac. And we've also noted in our supplemental briefing that in 2020, after the 2020 strike, this court entered a temporary restraining order, shutting down the pipelines until certain tests could be done to guarantee that they were safe to resume operation. And in doing so, this court found that the severe risk of harm that was created by Enbridge's actions was, quote, so substantial and irreparable and endangers so many communities and livelihoods and the natural resources of Michigan that the danger far exceeds the risk of financial loss to the defendants. We've also cited in our supplemental briefing that in November of 2023, the Michigan Public Service Commission found, and I quote, in the last 5 years, the dual pipelines have experienced 2 incidents that could have resulted in a catastrophic release of Line 5 products into the Straits. A rupture of the dual pipelines would be catastrophic for the Great Lakes.
Mr. Bach, excuse me, incidents that could have resulted
in a catastrophic release of Line 5 products into the Straits. A rupture of the dual pipelines would be catastrophic for the Great Lakes, costing an estimated $1.37 billion in damages and resulting in long-lasting health, environmental, and cultural damages. The idea that this risk that has been noted repeatedly by multiple different authorities is something that is so impermissibly speculative that a lawsuit cannot even be brought forward to challenge it or to seek to guard against it is without merit, Your Honor. We cited a case, several cases in our supplemental briefing that says that nuisance claims at this stage should not be dismissed because they necessarily present factual disputes. We have stated a claim on which relief can be granted, and that cannot be dismissed at this stage. Your Honor, if I can once again just confer with co-counsel to make sure I haven't left anything out. Just one moment, please.
Sure.
Thank you, Your Honor. I believe that concludes my response to Mr. DeRozier's argument.
Going back to the format that we agreed upon at the beginning, did you anticipate, the two of you, that at this point Mr. DeRozier would present a rebuttal argument to that, or did you intend, Mr. Bach, to move on to separately, in some sense, your motion?
Your Honor, I don't want to speak for Mr. DeRozier, but I think my anticipation was he would get a rebuttal because this is his client's argument, and then we would then move on to the Attorney General's motion where I would argue first, he would respond, and I would rebut.
That's the way I understood what you had told me earlier. Correct, Mr. DeRozier?
Yes, that's correct, Your Honor, if that works for you.
You can proceed, Mr. DeRozier.
Thank you, Your Honor. And I will try and keep my rebuttal brief. So just consulting with some notes that I took when Mr. Bach was speaking. Let's start, I guess, with Pipeline Safety Act. I think that it's really important to distinguish, as an initial matter. Mr. Bach talked a lot about how the Pipeline Safety Act defines safety standards, and it does. But the Pipeline Safety Act isn't just about the safety standards that that PHMSA chooses to incorporate and apply to pipeline operations. And we discussed this in our brief, but if you go to the very first portion of the Pipeline Safety Act, it's section 60102. That's where the Pipeline Safety Act describes very broadly the safety concerns, the risks. I don't think that there is anything improper about Mr. Bach took us to task for referring to safety standards in different ways. But I think the important thing for you is to take a look at what the Pipeline Safety Act is intended to do. Everything about the Pipeline Safety Act is intended to provide adequate protection. And again, like I said, this is in section 60102. It's to provide adequate protection against risk to life and property posed by pipeline transportation. It surely does apply to all of the things that Mr. Bach talked about, but it is quite broad in that regard. The other thing I wanted to point out is if you take a look at the cases, and I don't want to get into all of the details, it's all in the briefing, but we cited several cases that make the point quite clearly that safety standards aren't just those that a state puts into a regulation or a statute. Safety standards also include efforts by states, by private parties to bring state law claims to shut down an existing operating pipeline. That is an attempt to impose a safety standard in the sense that's preempted by the Pipeline Safety Act. So it doesn't have to be, it's not limited only to situations where you have a statute or a regulation that contains specific standards. So one example, the Olympic pipeline case that we cited there, that actually involved a contract between the pipeline operator and the city. And so, again, contract law has a common law genesis. We also cited for the court the Williams pipeline case. That's a really good case. We think in terms of illustrating how asserting a common law claim for purposes of attempting to enjoin an operating pipeline, however you characterize that claim, whether it's nuisance, whether it's here an attempt to revisit a prior location decision, which I'll get to in a moment. But the Williams pipeline case that involved a county that brought a nuisance claim, sought injunctive relief in an attempt to shut down an existing pipeline. And so what the court said there is you can't get injunctive relief because that's preempted. Mr. Bach talked a lot about how nuisance claims in general may or may not be preempted. And that might be true in a case, as I alluded to in my remarks at the beginning. If you have a nuisance claim that relates to a release of a product from a pipeline, well, then you have the tort damages provision in the Pipeline Safety Act that allows for that to be acted upon. That's a much different scenario than when you're using a state law claim in an effort to enjoin an operating pipeline based on safety concerns, standards that are within PHMSA's exclusive purview. So I think that's a very important distinction to make. It's what is the relief being sought? Is it damages, in which case the Pipeline Safety Act allows for tort damages. But when you're talking about seeking to enjoin an operating pipeline because of perceived safety risks, that's where, in our view, there are no cases that the Attorney General cites, other than the Bad River Bend case, which I'll get to in a moment, that countenances the closure, the permanent closure of an interstate pipeline on the basis of perceived safety risks. Now, with respect to the Bad River Bend case, the only reason that the district court in that case, and again, that case is also on appeal. I mentioned the fact that it may make sense to wait and see what the Seventh Circuit does with that. But with respect to the ordering of the shutdown in that case, number one, it was based that there was a determination made there that there was a trespass. Here, there is no trespass claim. And despite Mr. Bach's suggestions, the Attorney General hasn't cited any authority that lets a location or routing decision that's made here, the 1953 easement, be revisited later without countermanding the Pipeline Safety Act. Because when you are seeking to do that on the basis of safety concerns, you are running directly afoul of the Pipeline Safety Act in its effort to make sure that everything relating to pipeline safety goes to PHMSA. Now, so there is no trespass claim here. So in our view, the Bad River Bend case is not helpful at all. But the distinction also between, the difference between, one of the questions I think that you raised, and Mr. Bach got into this, sort of the difference between when PHMSA has an exclusive role and when other regulatory agencies, maybe when even states have a role. It's important to not to confuse the fact that you have to, again, in the cases that the AG relies on, there may be instances where if there's a release, not only can you potentially get damages, but in the event of a release, at that point, there is a role for other regulators to come in, and there is a role for the state. But we're not talking about that here. Here, we're talking about an operating pipeline that is being sought to be shut down on state law grounds because of claimed safety concerns. And as I mentioned, a sort of an ultimate assertion of a safety standard, which is that the pipeline can't operate safely on the bottom of the strait. So I wanted to sort of leave you, broadly with those couple of points. With respect to the again, with respect to the revisiting or relocating, and again, I think it's just a matter of looking at the statutory language as interpreted by the courts that have looked at it. It's that the state does have a role in prescribing. It's given to the state to prescribe the location of a pipeline. And here that's already been done. What's missing is any authority that lets the state come in after the fact and seek to revisit that location decision that's already been made. I apologize, bear with me here for a moment. I think that's what I wanted to address on the Pipeline Safety Act. Oh, no, I apologize, Your Honor. A couple other things I wanted to mention. So Mr. Bach talked a bit about the Davis versus Sunoco case. And what I want to simply say there is the Davis versus Sunoco case, and we address it in our brief, it fits exactly within sort of the paradigm that I just got done talking about. If you look at that case, it was an air pollution case. The plaintiff sued for air pollution, and the Court of Appeals ended up concluding that that's not something that is preempted. And so that, of course, is not what we're dealing with here. We're not dealing with, again, an effort by whether it's the state, by a property owner seeking to recover for damages as a result of the operation of the pipeline. This is a currently operating pipeline. It's been operating for 70 years. There's never been a release in the straits. And so it's a totally different situation that the Court of Appeals was addressing in the Davis versus Sunoco case. So I think with that, that's what I wanted to say about the Pipeline Safety Act. Turning to the treaty, and again, Mr. Bach obviously the Attorney General does not agree with our view of the treaty. I would just point out again, if the court were interested in seeking the views of the United States, of course, it has the views of Canada. That's always an option. But I think the important thing with respect to what the U.S. said in the Bad River case, which Mr. Bach talked about, is the United States was quite clear about the interests of the United States in seeing the treaty be upheld. The treaty is self-executing. Article 2 has very specific provisions that do expressly prohibit what public authorities can do. And there's no dispute that that includes state courts. And so the only hedge, if you will, in terms of what the U.S. brief had to say in terms of the relief that was ordered there, and again, that's all on appeal, but all the U.S. brief talked about was the need, in its view, for the court to weigh the treaty obligations, including Article 2 and its prohibition against a permanent shutdown, against something that's not at issue here. In the Bad River case, there was a countervailing tribal treaty that was raised, and that was part of that case. And so that was the only reason that the United States didn't fully go all in on the Transit Pipelines Treaty. It was because of, in its mind, the need for the court to take into account the tribal treaty. So I don't think there's any reasonable argument that the United States view of the way the transit treaty pipeline provisions work is inconsistent with anything that we're saying here. With respect to the Portland pipe case that Mr. Bach addressed, I wanted to point out there that the problem with there's a couple problems with the Portland pipe case. First of all, the Portland pipe case started out its entire discussion of the treaty, rendering it dicta, with an observation that the treaty, in the court's view, did not even apply in that case because there was no transit pipeline. So everything that the court went on to say about the treaty is dicta. It doesn't have any persuasive value here. The other problem with Portland pipe is that, number one, it didn't involve an attempt to shut down an existing pipeline. And two, it was the ordinance provision there dealt with something totally different. It was loading of crude oil onto tankers. It was the building of a new structure. So again, a totally different scenario than the Attorney General's claims here. The other thing that the court noted there was that neither the United States nor Canada had expressed any objection to the ordinance there. So for those reasons, we think that Portland pipe is not a case that you should put any stock in. Now, as Mr. Bach mentioned, the Bad River Court did also address the treaty, but there we think, again, what the Bad River Court said, in addition to being on appeal, is not helpful here. So the treaty was raised in that case in two ways, affirmatively and defensively. Enbridge raised the treaty affirmatively because it had a counterclaim in which it asked for the court to direct the tribe to issue a particular water quality certification that was necessary under the Clean Water Act in order to do some work near the pipelines on the reservation. All the court said was there that the Enbridge could not use the treaty affirmatively as part of that counterclaim. And so that's one difference between that case and this one. And then even more importantly, as relevant here, the tribe, with respect to that Clean Water Act certification, was the appropriate regulatory authority to issue that certification. So that, again, is completely different from the situation that we're dealing with here, where we have an operating pipeline and the Attorney General is the one that's coming in and is attempting to shut it down and is not, in our view, the appropriate regulatory authority. As the United States has made clear as well, it's PHMSA that is the appropriate regulatory authority when it comes to an operating pipeline. And now the treaty did come up in one other respect, and Enbridge did raise it defensively. But there, the problem with the Bad River Court's decision is it brushed it off. It certainly didn't reconcile its eventual shutdown order, which again is on appeal, and which even the U.S. takes issue with in its amicus brief in that case. It certainly didn't reconcile the shutdown order with Article 2, which, as I said, is plain and express on its face in preventing public authorities from permanently shutting down a transit pipeline. And so, so for that reason, we think that the Bad River case is just not helpful in terms of the court's assessment of the treaty issues in this case. And again, should the court have any question, we welcome a request that the U.S. supply its views here. The other thing
let me ask you both this. As to the transit treaty analysis, I assume both sides want me to analyze that as if Canada remains a sovereign nation, not a state of the United States. There's no need to answer that. I'll analyze it as the current status that Canada is a sovereign nation.
We would ask you to make that assumption. Thank you, Your Honor. So the other thing I wanted to mention about the treaty. So Mr. Bach talked about how if our view of the treaty is accepted, that even private landowners would have no remedy in the event of a trespass or other, improper incursion by pipeline operations. But that's simply not true. And we've made that distinction, I think, pretty clear in our briefing. Nothing in the treaty prevents the ability of a landowner from seeking damages. And it's the same with the Pipeline Safety Act. There's no prohibition against seeking damages as a form of relief. All we're talking about here, again, this applies both to the Pipeline Safety Act and it applies to the treaty. It's when a state comes in and is seeking injunctive relief based on safety concerns that the Pipeline Safety Act says that the state can't do that. And then when it comes to the treaty, when it is an operating pipeline, the treaty is quite clear that the flow of hydrocarbons are not to be impeded. Certainly not in a permanent way, as the Attorney General is asking the court to do here. And in fact, that request that the Attorney General is making here, that does put it, Mr. Bach talked about how the standard, I don't think we disagree about the standard. It's, is there a direct conflict between the relief that's being requested or only an incidental conflict? And here, the relief that the Attorney General is seeking in terms of a permanent shutdown of Line 5, it could not be more of a direct conflict with the foreign policy that's expressly stated in the treaty. And so for that reason, we think that the attempt to avoid the effect of the public affairs doctrine, it doesn't carry any weight here. Let me just check my notes if you don't mind bearing with me for a moment. Oh, I know. I wanted to mention, yeah, the other thing that the treaty does, and this is, I think, once again, consistent with everything that I've said about the Pipeline Safety Act. It's really important to make a distinction between new pipelines and existing pipelines. Once there is a provision in the treaty that deals with or that differentiates between pipelines that are already built and future pipelines, all we're talking about is an existing operating pipeline, and that's been operating for 70 years. Let's see, I think, okay, and I know I said I was done on the treaty. I think now I am done on the treaty. So I wanted to just wrap up very briefly by touching on a couple of points on the state law claims. With respect to the claim that the public trust doctrine is violated by continued operation of Line 5, I don't want you to have any mistake about what our argument is. It's simply that it's not about whether, we've never suggested that it's the legislature that's the only authority in Michigan that has a say about the public trust doctrine. We acknowledge that the Supreme Court in the Glass case was very clear about the courts having a role as well. But again, Glass didn't involve environmental protection, right? So all we're saying is that when you look at Article 4, Section 52 of the Michigan Constitution, it's where there is a claim being asserted that there is a threat to the environment. It's when that occurs that the Michigan Supreme Court, again, this is the Preserve the Dunes case that we cited in our briefing. The Michigan Supreme Court has said that when you're talking about environmental risk, environmental protection, that is when you have to look to MEPA. And so we think there's just no ground for there to be a separate sort of freestanding public trust doctrine claim. The Supreme Court has said you can't do that. You have to look to MEPA. And that sort of then takes us, I think, to the final point about this sort of the what Mr. Bach described variously as the risk, as the threat. that the Attorney General claims is posed by the continued operation of Line 5. Not only has there never been a release on Line 5 in the Straits in the 70 years it's been operating, the more important thing is that if you listen carefully and look at the briefing, look at the complaint that the Attorney General filed, everything that's being alleged here is a hypothetical situation. It's a possibility. But that is what both under public nuisance and even more strongly under MEPA is simply not permitted. You can't even get out of the gate if your MEPA claim or if your public nuisance claim is based on a purely hypothetical harm. It's not about showing that or alleging that there's a risk or that there's a threat. It has to be more than that. And especially when it comes to MEPA, again, the statutory language is crystal clear, is that there is either harm has occurred or it's likely to occur. And the Supreme Court, in construing that language, has said that that means that it's probable. And so again, I would say that all you have to do is look at the face of the complaint to see that that standard is not even close to being met here. And we don't think that any amount of discovery, which Mr. Bach had referenced, is going to change that. All you have to do is look at the complaint, give the benefit of the doubt to the allegations in the complaint. On its face, the complaint fails to state a harm that would be actionable as either a public nuisance or a violation of MEPA. And so unless you have any questions, I think that concludes what I wanted to say
All right.
in my
Thank you.
rebuttal.
Thank you, Mr. DeRosier. Mr. Bach, do you want to go on to your argument? Do you want to take a break and then go on to it? Ms. Werner, I should probably ask you as well. Would you like a few minutes to rush?
Yes, please.
Okay.
Your Honor, before we do, I wanted to ask the court if I could be permitted a brief rebuttal to what Mr. DeRosier said right just now, either before or after the break is fine with me. I would prefer before if possible, and of course would have no objection to a reply from Mr. DeRosier, but just there were some new things and I think
Go
some
ahead.
things that need to be addressed. Thank you, Your Honor. Sorry. And if it's okay, I'd like to just reply to Mr. DeRosier's rebuttal as to a number of points. And I will probably not do a good job of taking these in the exact order that he took them. I might jump around a bit if that's okay with the court.
Sure.
First of all, as it relates to Mr. DeRosier's rebuttal related to the treaty, I need to just make a few quick points. Mr. DeRosier said that he does not think the Bad River Band case is helpful here because it did not involve a trespass claim and because it did not address, his words were, did not reconcile Article 4 with Article 2. And I just want to say a couple things on that real quick. First of all, I agree to the extent that the Bad River Band case is not helpful at all to Enbridge because it's contrary to Enbridge's position, but I think it's very helpful to the court. First and foremost, we've cited this in our supplemental response. The Wisconsin federal court absolutely reconciled Article 4 with Article 2. We quoted it in I believe it was our supplemental response, where the court pointed out that Enbridge relied on Article 2, but that Article 4 expressly says it applies notwithstanding Article 2. And so the court did absolutely address that. And again, I would simply point out that neither court to consider it nor the Department of Justice in its brief agreed with Enbridge's position. Mr. DeRosier said, I don't think there's a reasonable view that the U.S. view of the transit treaty is inconsistent with anything Enbridge is saying here. But the fact of the matter is the United States considered the preemptive effect of the treaty and held that, or not held, I should say, argued. It's important to remember this is an amicus brief, not a court holding. The United States argued that the Wisconsin federal court had the authority to fashion an appropriate remedy for trespass, which it acknowledged could include a shutdown order. And so that is absolutely inconsistent with everything that Enbridge is saying here. What the United States said in its amicus brief was simply that the court should have considered potential harm to the United States if there's a shutdown, and that leads to international arbitration, and the United States winds up having to pay a money judgment. Mr. DeRosier also stated that the United States argued that PHMSA is the appropriate authority with regard to pipelines. That was only argued by the United States in the context of the band's public nuisance argument. And there's a very important distinction that we addressed in our supplemental briefs between the band's public nuisance argument and the Attorney General's public nuisance argument, and I'll just summarize that briefly. The band sued Enbridge under the federal common law of nuisance. And the question before the Western District of Wisconsin, and the question that the Department of Justice addressed in its amicus brief, was not one of preemption, but one of displacement, whether the Federal Pipeline Safety Act displaces the federal common law of public nuisance. That is a completely and materially different legal analysis than whether a federal statute preempts the state common law of public nuisance. Displacement and preemption are two different things. And we've cited authority in our supplemental briefs in the response and the reply that says that when the courts are considering whether a federal statute displaces the federal common law, they begin with the presumption that it does, because it is for Congress and not the federal courts to articulate the state of federal law. And so when Congress has spoken to an issue, the courts presume that the federal common law is displaced. And that was what was at issue in the Bad River Band case. Here, the Attorney General has sued under the state common law of public nuisance and the state common law related to the public trust doctrine and MEPA. And we've cited clear authority in our briefs that when courts are deciding whether federal statute preempts state law, they begin with the presumption that it does not have any preemptive effect. And they only find state law to be preempted where that is the clear and manifest intent of Congress. And so the Department of Justice did not even address the question of whether the Attorney General's state common law claims are preempted. And moreover, it's important for the court to keep in mind that is an amicus brief from a non-party on appeal. It is not a decision of a court. The court that considered the question, the Western District of Wisconsin, expressly held that the treaty did not preempt trespass claims or public nuisance claims. Now, on the topic of trespass, Mr. DeRosier pointed out that the Attorney General has not sued Enbridge for trespass. And that is correct at this point, Your Honor. The Attorney General's lawsuit challenges the validity of the 1953 easement contract. If the Attorney General was to lose this case, there could be no trespass claim because Enbridge would have a valid easement. And so any trespass claim would not be ripe at this time. I think the Attorney General has to prevail. But regardless, that's a distinction without a difference. The Bad River Band case was a case where the Bad River Band argued that Enbridge's easement had expired, and so it was operating Line 5 on the band's sovereign land, not even Great Lakes submerged lands, this was upland, without a valid easement. Therefore, it was in trespass. And the Western District of Wisconsin held that no federal law preempted that case, that claim, nor did any federal law preempt the band's federal common law public nuisance claim. The Attorney General here argues that Enbridge never had a valid easement because the 1953 easement is invalid, and therefore it is operating Line 5 on the state and the people's Great Lakes submerged lands without a valid easement. And so the same analysis applies. It doesn't matter if the Attorney General framed her claims as trespass or something else. The question is the preemptive effect. And the only court to consider the issue has held that the treaty does not preempt a federal common law public nuisance claim. And so Enbridge's argument is even weaker here with regard to preemption of a state common law public nuisance claim because the test is different. We noted in the briefing, but Enbridge argued in its supplemental briefs that where the Department of Justice argues that the Pipeline Safety Act displaced the band's public nuisance claim, that same analysis should apply a fortiori or with greater force to the Attorney General's state public nuisance claim. But actually the opposite is true. It applies with less force because it's a completely different test and it's much more deferential and unlikely to preempt state law. And again, it of course merits mentioning that the actual court holding was that the band's claim was not preempted. That was just advocacy from an amicus. Mr. DeRosier mentioned that the court should request an amicus brief from the federal government and sort of sit tight for a matter of months until that arrives. But we already have an amicus brief from the federal government on the preemptive effect of the treaty as it relates to whether Enbridge can operate Line 5 on someone's land without a valid easement, and as it relates to public nuisance actions. And so we know there's absolutely no need to seek another brief that would address those issues or similar issues. As the court is aware, when it remanded this case to this court, the Sixth Circuit held that this case belongs in Michigan State Court. It's here, it's in the appropriate form, and we sort of already know what the Department of Justice thinks. Now, I would also note that there are two distinctions I'd like to make that are sort of overarching distinctions where I think Mr. DeRozier's rebuttal muddied some issues a little bit. Mr. DeRozier keeps referring, and Enbridge in its brief, keeps referring to this case as seeking a shutdown of Line 5, a permanent shutdown of the pipeline. And I want to make clear that's not an accurate framing of the Attorney General's claims here. The Attorney General's claim is that a 4-mile segment of Line 5 cannot be located on the bottomlands of the Straits of Mackinac, and that having it located there violates a number of Michigan state laws, and that the conveyance that purports to authorize it was never valid. This is not an attempt to permanently shut down the entire pipeline. It's an attempt to get it out of this extremely environmentally sensitive area where it currently exists without valid permission. And so to characterize this as some overbroad relief that has never been granted anywhere seeking a permanent shutdown of the entire pipeline is simply not accurate. And the Bad River Band's claims were the same. Their claims there were shut it down or reroute it, but in any event, get it off of our land because you don't have permission to be there. And it's violating the law to be there. That's the exact same thing the Attorney General seeks here. And so I think that's important to note. Mr. DeRozier mentioned that the Portland—
Excuse me, Mr. Bach.
Yeah.
I just wonder if anyone else is having some slowing down of the audio or if it's distinctly me.
I think it's you, Ms. Warner.
That's weird, Your Honor, because we're on the same network, but
I know.
I'm confident that nothing was
Believe me,
missed,
I cannot explain it.
but the kind of unstable, so hang in there.
Thank you. And I'm happy to repeat anything I said to the best of my ability. I do want to make sure, Ms. Warner being the stenographer, it's crucial that we get a clean record of this case. And so I'm sorry to hear that we're having those difficulties, and I'm happy to repeat or to the best I can recreate anything that I said. The next thing I would say, this idea that PHMSA is the only appropriate authority with regard to pipelines, Mr. DeRozier argued that the United States said that in its brief. That was only with regard to the common law public nuisance claim. It did not say that PHMSA regulates Enbridge's ability to operate a pipeline on someone else's land without a valid easement. And so I think that's important. And I think we've cited a lot of case law that shows that other governmental authorities enforce the laws against pipeline companies all the time. Davis, the prior cases against Enbridge. And in general, I want to point out one other broad distinction. Mr. DeRozier has made the argument just now in the rebuttal that it's fine if someone sues a pipeline company after a release to get damages for environmental protection statutes, but that they don't have jurisdiction before a release has occurred. And that is contrary, it's completely contrary to law, and it creates a very dangerous problem where it creates this presumption that nothing can be done unless there's a release. And then after there's a catastrophic release in the Great Lakes, people can sue Enbridge for money, right? He talked about the tort savings clause. And I want to point out that in the Pipeline Safety Act, in the section 60121 that governs actions by private persons, where Mr. DeRozier is pointing to, you can have tort savings clause. It expressly preserves any right to relief that a person or class of persons may have under another law or at common law. And then there's a separate tort savings clause that we've referenced. And so I think this idea that the Pipeline Safety Act forbids anyone other than PHMSA from enforcing any laws against pipelines until there's been a release, and then they can enforce the law and get money damages after the fact, that is completely contrary to how our law works. You are absolutely, and this applies to the public nuisance and MEPA claims as well, you do not need to show that it's probable that there will be a release. That we've cited in our prior briefing from 2020, we cited case law that says there's a sliding scale where the gravity of the harm is more significant, the showing of likelihood can be reduced. And I think where we've got two different anchor strikes in recent memory on the pipeline already, I think there's absolutely no way the nuisance and MEPA claims can be dismissed. that covers the treaty and the state law issues. Just very quickly, when Mr. DeRozier offered rebuttal on the Pipeline Safety Act, he pointed out that pipeline safety standard is a broad term, he argued, and said that anything that would shut down a pipeline is a safety standard. And I want to point out that there's absolutely no support for that in the Pipeline Safety Act or in any of the case law. Pipeline safety standard is not a broad term. He referenced a couple of things that I think were, one was inaccurate, one was a sort of gloss that was technically accurate, but created a misimpression. He mentioned that the Olympic pipeline case was about a contract and that the city of Seattle could not revoke a contract or could not refuse to renew a contract. And that is true. But the problem is that the city of Seattle said it would not renew the contract unless Olympic Pipeline Company, and I quote, comply with a list of pipeline safety demands, right? That was a clear attempt. You know, the court looked at what the city wanted the pipeline company to do. And the pipeline company or the city was saying, you can continue to operate your pipeline if you impose, they literally said, pipeline safety demands. That's completely different than what the Attorney General is doing here. Similarly, Mr. DeRozier referenced the Williams case, I believe it's Williams versus City of Mountain View, and said that there the court held that a nuisance claim was preempted, and that is not the case. The court there expressly held that it was assuming for the case of a preliminary injunction motion that a nuisance action was not preempted, but it declined to enter a preliminary injunction based on the facts of that case. It conducted a factual analysis, just like this court did here in 2020 in this case. And so I think there's a serious problem with the framing overall of the Pipeline Safety Act and the related case law, where Enbridge first says these standards are really broad, and anything that would shut down a pipeline is a safety standard, but that's not true. The Pipeline Safety Act doesn't make any distinction between a shutdown or any other injunctive relief versus damages. The Western District of Wisconsin held that Line 5 could be shut down and indeed ordered that it be shut down. And multiple other courts have preserved nuisance and other common law claims. Those cases just didn't involve a remedy that would involve a shutdown. Here, again, the Attorney General is not seeking a permanent shutdown of the pipeline. She's seeking an order that says Enbridge has to shut down and decommission the 4 miles that are in the Straits of Mackinac. Nothing at all that the Attorney General is arguing for here is asking the court to permanently shut down the entire pipeline. Let me just check. With regard to the Davis versus Sunoco case, Mr. DeRozier drew a distinction between the fact that that was an air pollution case and this case involves concerns about water pollution. And he says it's totally different because there's never been a release in the Straits of Mackinac. And not to belabor the obvious, but the Pipeline Safety Act draws absolutely no distinction between the type of environmental protection law or the concern behind a public nuisance claim. It doesn't matter that one is air and one is water. The relevance of Davis versus Sunoco to this court's consideration here is that the Michigan Court of Appeals expressly held that Michigan's environmental protection statutes, a different part of the same act that MEPA is included in, and Michigan's common law of public nuisance are not preempted by the Pipeline Safety Act where they are being applied as generally applicable environmental statutes that are not targeted specifically at pipeline safety. And that's the same thing here. The Attorney General is seeking to enforce generally applicable state contract, property, and environmental laws that don't say anything at all about pipeline safety. And that's not an attempt to impose a pipeline safety standard. I believe that, Your Honor, if I can just very quickly confer with co-counsel, I think that concludes Sir Rebuttal.
Sure.
That is all, Your Honor. Thank you.
Mr. Bach, if the part of the pipeline that's in the Straits is shut down, doesn't that effectively shut down the whole pipeline?
At least temporarily, Your Honor. But my issue is with Mr. DeRozier characterizing the Attorney General's claims for relief as an effort to, he repeatedly said, permanently shut down Line 5. And the answer is that, a property owner absolutely has the right to enforce the limits on their easement, the validity of an easement, and the requirements of state law to require that a pipeline be located somewhere other than on their property. And that's what the Attorney General is doing here. And that does not prevent in any way Enbridge from rerouting its pipeline, which I understand in the Bad River Band case, my understanding is that Enbridge is working with the state of Wisconsin to get permits to reroute Line 5 around the band's reservation. And that's, a similar thing as to what would need to happen here. And so I think it's part of the issue here, Your Honor, is that Enbridge is repeatedly characterizing the Attorney General's claims and the Attorney General's request for relief as something that is completely outlandish and that has never been granted before, and that is a permanent shutdown of this major international oil pipeline. And that is not an accurate characterization. What the Attorney General is saying is you don't have a valid easement, and the law does not allow a 4-mile stretch of the pipeline to be located in this specific location. That's why this is a locational issue, which is expressly preserved by the Pipeline Safety Act. That is why it's an appropriate matter for the Attorney General and the court to bring forward and adjudicate. And I just want to make sure that framing is correct. And with that, does that answer the court's question?
It does.
Thank you, Your Honor.
Mr. DeRosier, do you want to have an additional rebuttal at this point?
Yes, Your Honor, if you wouldn't mind, I do have a few things I'd like to say. I won't be long. And thank you for bearing with me as I try to shift my seat here out of the sun. Despite my best efforts to close all my blinds, the sun is keeps making its way on me. In any case, I guess continuing where the discussion just left off, I think I would just suggest it's very hard. Should be very hard to take seriously the idea that seeking a shutdown of a 4-mile stretch of the pipeline that goes directly through the state of Michigan is not an effort to permanently shut down the pipeline in the state of Michigan. I don't think that's the first we're hearing any such distinction, and the idea that it's really no different than the reroute situation in the Bad River case. I just don't think there's anything to it, and I don't know that you need to spend a lot of time giving that any credence. Starting with the Pipeline Safety Act, one of the things I wanted to mention, the Williams pipeline case has come up a lot. I just want to be very clear. Yes, the court did suggest there that it was assuming, for the sake of its injunction analysis, that a nuisance claim per se is not necessarily preempted. But what the court did end up concluding is that, but injunctive relief based on a nuisance claim is preempted. So again, that just goes back to the point that I've been trying to make throughout, which is that there's a difference between seeking to enjoin an operating pipeline under a state law theory, whatever that theory is, and seeking damages. We're not talking about nuisance, in and of itself. We're talking about when the requested relief is an injunction, and that's exactly what the Williams pipeline case addressed. One more thing on the Davis versus Sunoco case. I think if you go and look at that case, you're going to see exactly the distinction that we're drawing here. The claim in the Davis case, it was air pollution. It was a release from the pipeline facility as it pertained to Sunoco in that case, as there was no claim against Enbridge relating to releases from its facilities. The claim against Enbridge actually related to construction work. I think you'll see that if you look at the opinion, but be that as it may, the point is that nothing in the Davis case even remotely supports the Attorney General's claim that it allows for a state to come in on a state law theory and seek to enjoin a pipeline, notwithstanding PHMSA's express preemption provision. On the treaty, Mr. Bach, and I apologize if I misheard, but I hear him sort of repeatedly suggesting that it's only the parties that have anything to do with the treaty, that the treaty is not binding beyond the parties. Well, that's not an accurate reading, certainly of Article 2, which expressly prohibits public authorities from taking any action to interfere with the international operation of a transit pipeline. It has the force, therefore, of federal law. It's self-executing. And so I think it's important to keep in mind here that the treaty is not just about the parties. The dispute resolution portion under Article 9, yes, but Article 2 is a statement of positive law that is enforceable. Back to briefly this idea of the Bad River Band having involved a trespass claim and what we're dealing with here. And I hope I didn't misstate in saying that Bad River Band did not involve a trespass claim. That was the whole focus was a trespass claim. Here, there is no trespass claim, as Mr. Bach referenced. And I think there's a very big difference between a party bringing a trespass claim when the pipeline operator is alleged to not have an easement to continue to operate versus a situation like this one where there is an easement in place and has been in place for 70 years. And all we are dealing with here, and I know Mr. Bach is trying to say that it's a distinction without a difference, but in terms of the Pipeline Safety Act, it's a huge difference because the location and routing decision was prescribed, as I've been saying, already in 1953. And the Attorney General has not cited any authority that the Pipeline Safety Act allows that location or routing decision to be revisited based on a theory that it wasn't properly issued then because the proper safety findings weren't made. And I also take issue with the notion that the public trust doctrine doesn't deal with environmental protection. That's the whole premise of the assertion of the public trust doctrine here. It's that there were not findings made in 1953 when the easement was granted for the pipeline. The claim is that pipeline safety, effect on the public trust wasn't taken into account. Now, as we've said, we think that no matter how you look at what the easement says, it easily satisfies any requirement that Obrecht might put into play here. And all you have to do is look at the statute that I mentioned. One of the statutes that the court said was just fine, 1959, excuse me, I think it was 1959 Public Act 84. And again, it's the one that it's the one that we attached to our original reply brief. I think that the idea that the findings in the easement were not sufficient to satisfy Obrecht, it really is elevating form over substance. It's suggesting that some specific verbiage was needed. The Court of Claims looked at it and said, didn't even remotely see the distinction that the Attorney General is trying to make. Said, well, the easement said it's in the public welfare. And Mr. Bach says, well, he didn't use those words, said public interest. That kind of goes ultimately to our point, is that the criticism of the easement under Obrecht, it just doesn't hold water in our view. Let me just check my notes here. I think I covered I know what I wanted to mention too. Mr. Bach mentioned the citizen suit provision in the Pipeline Safety Act, and that's something that's addressed in the briefing, and I don't want to belabor it, but it does not have nearly the broad, all-encompassing, you can bring any state law claim you want, notwithstanding the Pipeline Safety Act's otherwise, express preemption. The citizen suit provision is very specific. It provides that, on the one hand, you have the ability to bring a lawsuit in federal court to enjoin violations of the Pipeline Safety Act. The saving provision that Mr. Bach is referring to says that ability to go into federal court doesn't restrict the ability to seek other relief. But what that doesn't mean is that you just disregard the express preemption that the Pipeline Safety Act otherwise has. And so I think, and we cite a couple of these cases in our brief, the extent to which other parties have tried to make that argument. In the Williams Pipeline case, for example, cited a very similar Federal Water Pollution Control Act provision that the U.S. Supreme Court addressed that had the exact, or if not exact, the very similar provision that basically just says that might give you the ability to bring relief other than the citizen suit, but that doesn't have anything to do with the broader preemptive effect that a particular statute like the Pipeline Safety Act might have. So unless the court has any questions, I think, let me just take a look. No, I think that's really it. The only other thing I guess I'll leave you with is we've gone back and forth a lot about safety standards. What's a safety standard? And so I would just encourage you, to go back to the briefing, which I know you will. We cite plenty of cases that talk about how safety standards can be sought to be imposed under common law claims. It's not just statutes, it's not just regulations. And so, we think that this idea of getting caught up in the idea that, well, the Attorney General isn't saying you need to do this or that with respect to the pipeline. What she's saying is that the pipeline can't operate safely on the straits. And that's an attempt to shut down the pipeline based on a safety concern. And like I said, in our view, that is absolutely an attempt to enforce a state law safety standard. And so with that, that's everything I wanted to address. I do appreciate your time.
All right, thank you, Mr. DeRocha. Let's take a break until 1 o'clock, and then we'll come back and hear from Mr. Bach.
Thank you, Your Honor.
Thank you, Your Honor.
I just want to remind everybody as we're coming back that we are still streaming on live on YouTube. And Judge Jimo will be with us shortly to start again.
Thank you, Ms. Smith.
Council, can you all hear me?
Yes.
Yes, I can hear you fine. Can you hear me?
I can. Judge, we are still live on YouTube. Go ahead.
All right, Mr. Bach, I think you're up, sir.
Thank you, Your Honor. And I think we've already covered many of the issues that are presented in the Attorney General's motion, and so this is going to shorten my argument outline substantially. And I hope the court will bear with me as I do my best to jump around I don't want to repeat things that we've already flogged pretty thoroughly. So I just appreciate the court's indulgence as I hop around in my outline a bit.
Sure, not a problem.
Thank you, Your Honor. Your Honor, the Attorney General is entitled to summary disposition as to count 1A of the complaint because Enbridge does not have a valid easement to locate and operate Line 5 in the Straits of Mackinac. The law has been clear for 133 years that a state lacks the authority to convey any interest in Great Lakes submerged lands without first making at least one of two formal, duly recorded findings. The state has to find, as the court is aware, that either the proposed conveyance will enhance the public's right to use the lake and submerged bottomlands, or at a minimum, the state must find that the proposed conveyance will not impair those rights. Neither finding was made here. Now, I addressed this largely earlier, but I'm going to just very briefly reiterate the basis for this requirement, and that is the special character of the Great Lakes submerged lands and their waters. As the court is aware, in 1892, the United States Supreme Court issued its decision in Illinois Central Railroad Company versus State of Illinois, in which it held that a conveyance by the state of Illinois to the Illinois Central Railroad Company that included Lake Michigan submerged lands decades earlier was void, invalid since its inception, and had to be revoked because it had not been made with those due findings which it required. And this is because the law is clear that those lands belong not to the state government, but to the people of the state itself, and their rights have to be taken into consideration and addressed before those lands can be conveyed. When a state purports to convey Great Lakes submerged lands without making those findings, as the state of Michigan purported to do in 1953, it seeks to convey that which it does not own. The people's rights have to be taken into consideration, and these rights and the state's duty to protect them are perpetual, and any conveyance made without those due findings must be revoked because it is invalid. That is the case with the 1953 easement contract here. Now, Enbridge asserts three categories, essentially, of defenses to this clear legal requirement, none of which are valid. It first argues in its briefs that this requirement did not exist under Michigan law until after the easement was executed. It argues that the requirement did not exist until it was adopted by the Michigan Supreme Court in the Obrecht versus National Gypsum case in 1961. Second, Enbridge argues that the required findings were actually made. And third, it asserts that those requirements are preempted by federal law. Now, I'm going to be very quick addressing the preemption arguments because we've already addressed those very thoroughly earlier today and in the briefing. But I do want to briefly touch on three things. We were arguing preemption earlier. The court's very familiar with the parties' arguments. I do want to touch on three quick points that came up in Mr. DeRozier's last presentation that relate to preemption, and they therefore relate to this motion. So I'm just going to very quickly address those, and then I'll move on from preemption because I think the court is well informed as to the parties' positions on that issues. But first of all, earlier today, Mr. DeRozier, in terms of preemption, drew this distinction between saying you can get money damages as a form of relief under the Pipeline Safety Act, but you cannot get any sort of injunctive relief for any matter that involves an interstate oil pipeline. And he cited the Williams versus City of Mounds View case for that proposition. And I need to point out to the court that that is not at all what Williams says. Mr. DeRozier described it as creating a broad rule that injunctive relief is not available for actions including nuisance related to interstate oil pipelines. That is not what that court said. That court assumed that a nuisance action could go forward and considered, based on the specific facts of that case, whether to enter a preliminary injunction on behalf of the plaintiffs against the defendants. The court considered that and decided that the facts of that case did not warrant a preliminary injunction, which, as the court is well aware, Your Honor yourself having entered a form of a preliminary injunction, a temporary restraining order, in this case previously, preliminary injunctions are extraordinary remedies that are only available in certain circumstances. The fact that that court in Williams decided not to enter one does not in any way create a broad rule that injunctive relief is somehow not available or preempted by the Pipeline Safety Act. Quite the contrary. I think the fact that that court considered the elements of a preliminary injunction and opted on the facts of that case not to enter one says the opposite. It says you can get one. And that's what the Wisconsin federal court also did in the Bad River Band case. It entered a permanent injunction based on applying the injunction elements. So I just want to make clear, there is absolutely no authority to support the notion that the Pipeline Safety Act preempts injunctive relief. Additionally, Mr. DeRozier mentioned earlier that he heard me arguing that the 1977 Transit Pipelines Treaty is only binding on the parties. And I just want to make clear that's not an accurate characterization of my argument. I argue that Article 9 and its international dispute resolution provision applies only to the parties by the treaty's plain text. And it sounded like Mr. DeRozier agreed with that. I just want to make clear, the Attorney General is not arguing that other provisions of the treaty do not apply to everyone. Only Article 9 is limited to the parties, the United States and Canada. Finally, and this is particularly important for the Attorney General's motion here, Enbridge has argued consistently, and Mr. DeRozier reiterated earlier today, that the routing and location of Line 5 were prescribed by the state in 1953, and that the Pipeline Safety Act somehow preempts the Attorney General in this court from revisiting that decision. And Mr. DeRozier stated earlier that the Attorney General has cited no authority that says routing and location decisions can be revisited once they've already been made. And that's incorrect for two reasons. First and foremost, the Attorney General and her amici have cited a great deal of authority that says that very clearly. The Illinois Central case, the Obrecht case, and multiple other public trust cases that are cited in our briefs and in the amici briefs say that the public trust doctrine and the public's rights and the state's duties to enforce it are perpetual, and they never go away. And the state has a duty to protect them in perpetuity, to act as guardians of those rights. And Illinois Central and Obrecht are both cases where Great Lakes submerged lands were conveyed to a private party, and that conveyance was subsequently invalidated because it was not done correctly. That was the entire holding of Illinois Central. And, we and our amici have cited cases that say that, the power to revoke is an inherent power of the public trust. And also, we've cited cases under Michigan contract law in our recent supplemental response that say that under Michigan law, when a contract violates the law, it is invalid and should be invalidated by the court. And so the idea that we haven't cited any authority that allows revisiting this is simply not true. But there's a second and more fundamental problem with Enbridge's argument. Enbridge's argument appears to be based on the assumption that the Pipeline Safety Act preempts everything, and that it's the plaintiff's obligation to show some sort of exception to preemption. And we noted this in our briefs, and I noted it in the argument earlier today. That is the opposite of how it works. We've cited case law in our supplemental response and reply that says the burden is on the party asserting a preemption defense to show where the state law is preempted by federal law. The plaintiff is under no burden to prove the negative, to prove that their claims are not preempted. And nothing in the Pipeline Safety Act preempts common law causes of action or state law causes of action, including injunctive relief. It only preempts states from imposing pipeline safety standards. And Mr. DeRozier and Enbridge have created this dichotomy where they say, well, if the relief requested is monetary, if it's damages, that's not a pipeline safety standard. But if the relief requested is injunctive, then it is a pipeline safety standard. There's no basis for that in the text of the Pipeline Safety Act, and there's no basis for that in the case law. And we've cited, the Bad River case is a perfect example, the Bad River Band case where the court entered a permanent injunction. The Williams versus City of Mounds View case, the court considered whether to enter a preliminary injunction, decided not to on the facts, but certainly did not hold that that relief is not available. And so I just need to point out that Enbridge's framing of the issue is exactly backward, and it's seeking to transfer the burden related to preemption from Enbridge onto the Attorney General, because it's, of course, impossible for the Attorney General to find a provision in the Pipeline Safety Act that says, and a state is not preempted from revisiting its original decision that was not preempted in the first place, because it doesn't say that. It's hard to prove a negative, but the burden is on Enbridge to point to a provision in the Pipeline Safety Act that expressly preempts what the Attorney General is trying to do here, and there is not one. The only thing the Pipeline Safety Act says about who makes routing or location decisions is it says that the federal government, the Secretary of Transportation, does not have authority to do so, and that's in 60104E. And so based on that, there is simply no way that these are preempted. With that, I will move off of preemption. I'm sure the court's heard more than it cares to hear about preemption today. But I want to move on to Enbridge's other two categories of defenses. First, Enbridge has argued throughout its briefing that these due findings requirements did not exist under Michigan law in 1953. And these were primarily raised in its prior briefing, but I believe it reiterated them in its supplemental. And I just want to say that's simply not true. First and foremost, the public trust doctrine and the requirements under it became a part of Michigan law when Michigan entered the Union in January of 1837. We've cited that under the equal footing doctrine. Like every other state, the people's rights in Michigan's navigable waters and submerged bottomlands vested on that date, and it became a controlling part of the law. The U.S. Supreme Court issued its first decision that I'm aware of formally recognizing that requirement in 1892 in the Illinois Central case. And the Michigan Supreme Court expressly adopted that holding for the first time 4 years later in 1896 in People versus Silberwood. And in our briefing throughout this matter, we've cited several other cases over the ensuing decades where the Michigan Supreme Court reiterated that the rule of Illinois Central is the rule in the state of Michigan. There was the State versus Venice Land Company of America case and two others that we've cited in our briefs, and they're all cited in Obrecht. But those were multiple times between 1896 and the 1930s, the Michigan Supreme Court reiterated that rule. Then, when it issued its Obrecht decision in 1961, the Michigan Supreme Court was not inventing this for the first time. The exact quote was that the state of Michigan had, and I quote, long ago committed itself to the rule set forth in Illinois Central. So the idea that this was a new requirement in 1961 is simply contrary to the clear case law. This has been the law in Michigan since Michigan became a state. It's been expressly recognized by the Michigan Supreme Court since 1896, and it's been reiterated numerous times. Obrecht was not creating new law. It was restating what was already well settled, and it cited all of those cases in its opinion. I have already addressed Enbridge's argument earlier this morning that MIPA has somehow subsumed the common law. That's simply not the case for the reasons we stated earlier. And finally, Enbridge makes the argument, which we've already also touched on somewhat, that the required findings were actually made. And they point to the holding of the Michigan Supreme Court in the Lakehead case in 1954, which was completely unrelated to Great Lakes submerged lands and said nothing at all about the public trust. And they've pointed to statements made in the 1953 easement itself, which refer to the public welfare. But that is not what's required. The law is very clear that the state has to specifically make formal, duly recorded findings, assuring that it is protecting the rights of the people in their Great Lakes and their Great Lakes submerged lands. And those simply were not made here, and pointing to other findings does not satisfy that requirement. And so the Attorney General has filed this motion asking the court for a very specific piece of relief. And I want to be clear here because I want to make sure this does not get lost. The issue before the court today is only in the Attorney General's motion whether the 1953 easement contract is valid or not. The relief requested in this motion is a declaration, a declaratory ruling from the court that the 1953 easement was not a valid conveyance of an interest in Great Lakes submerged lands because the required findings were not made. Enbridge and its amici have said a lot in their briefs, and Mr. DeRosier has commented on it a fair amount today, talking about the negative impacts that would happen if there was a shutdown of the pipeline. And I want to make clear, and I know the court's aware of this, but just to be very crystal clear, the question before the court today is not whether to shut down the pipeline. In the Attorney General's prior briefing in 2020, and we reiterated it in our supplemental briefing, the request is to first determine the validity of the easement. Attorney General submits that the easement is not valid and the court should declare as much. Only then at that point would the case move to a remedy phase because, of course, any relief is going to require the court to consider the factors, the four factors of whether to grant injunctive relief, which I know the court is very familiar with. And so the Attorney General we've sort of studiously avoided countering those arguments because I want the court to rest assured that the Attorney General believes that by far the best, most accurate, and up-to-date research and expert studies show that a shutdown of Line 5 would not have the negative effects that Enbridge and its amici say it would. And in fact, in the Bad River Band case, Judge Conley, the Western District of Wisconsin, held a 6-day trial on what the remedy should be and ultimately determined that a shutdown was the correct remedy. But I want to make clear that for the purpose of today's motion, any argument related to the impact of a shutdown is a distraction. That is not the issue before the court today. The only issues before the court are with the Attorney General's motion, whether the easement is valid or whether the court should declare it invalid. And then with regard to Enbridge's motion, the only issues before the court today are whether the Attorney General's claims can proceed. And so with that, that concludes my initial argument. If the court has any questions, I'd be happy to answer them. But if not, I will just stand ready to respond to what Mr. DeRosier has to say. Thank you.
Mr. DeRosier.
Yes, thank you, Your Honor. So just picking up on where the discussion just left off, one thing I wanted to mention about Bad River, remember that, yes, so the court did order the pipeline to be closed in 3 years, not immediately. That's on appeal. So that's, that's an issue that's going to be resolved in the Seventh Circuit. We'll see what the Seventh Circuit said. And again, I've mentioned a couple times today, it might make sense to wait and see what the Seventh Circuit has to say. Of course, our position is that the court went too far. And the United States brief filed in the Bad River case agrees with that determination that the pipeline needed to be closed was something that failed to properly take into account the pipeline the transit treaty that we've been talking about this afternoon and earlier this morning. So in any event, I think that the Bad River case is something that, we've talked about it a lot. I just think that there is, it doesn't have quite the sway that the Attorney General thinks it does here. But I wanted to mention that briefly about the reality of the court's shutdown order in that case. But that also leads me to the fact that the shutdown order in that case, the court didn't deal with what you have before you in terms of the effect of the treaty, the effect of the Pipeline Safety Act on again these purely state law claims that don't involve a trespass claim where there's no easement. It's a totally different case that the Bad River Court addressed than what's in front of you. And so I would just urge you to kind of keep that in mind as you consider what makes sense to pull from the Bad River case. I wanted to touch briefly on the Williams pipeline case that Mr. Bach mentioned. And again, I want to be clear. What we're saying about the Williams pipeline case is what it demonstrates is that it's not enough to just say, oh, it's a state law claim and it asserts nuisance and it's not preempted by the Pipeline Safety Act. What the Williams court concluded, and it wasn't just a preliminary injunction, the court in a later decision ended up entering a permanent injunction. And the idea was, and sure, it was on the basis of those facts, but the point I think that you need to draw from that Williams pipeline case is the very point that when a state is seeking under a common law theory to shut down an interstate pipeline, not just on any basis, but on the basis of claimed safety concerns, that is something that the Williams court said it wasn't going to allow. And it did enjoin that effort. So I just want to make sure that we don't get too caught up in this idea of, well, it was just a preliminary injunction situation that the court addressed. It did also enter a permanent injunction. That takes me to the last thing I wanted to say about the Pipeline Safety Act part of this, and then I'll turn to the purely state law arguments. And that goes again, back to this routing and location debate that we're having. Mr. Bach cites Illinois Central, Obrecht as cases that say, well, the public trust doctrine is something that can, those conveyances can be revisited, but those are not Pipeline Safety Act cases. So what we're saying is that when you have a situation like here, where there is under state law a prescribing of the location, and where there is an attempt to revisit that location inciting decision, that is something where the Pipeline Safety Act kicks in and does have preemptive effect. And I think the case that's worth looking at, and it's discussed in the brief, but it's the Cowser case, where the court said that once a location or routing of a pipeline is chosen, the PHMSA regulations dictate at that point. And so that's all we're saying. We're not trying to overstate, again, this idea that all state law claims are preempted no matter what. What we're focused on is what the Attorney General is uniquely seeking here. And that is the permanent and injunctive relief that shuts down the 4-mile stretch of Line 5 that goes across the straits. Turning to the state law component. So I think and we've gone over this and I don't want to belabor it, but I think what is important to appreciate is where the disagreement is between Enbridge and the Attorney General is on this idea that a finding or a determination, don't even want to say finding, that a determination that's made at a time a conveyance of an easement is made, what needs to be said. The Attorney General's position is that Obrecht and Illinois Central require, again, some specific wording that needs to be used. And all we're trying to get across is that if you go to Illinois Central and you go to Obrecht, there is no such requirement of some kind of specific verbiage. So as we've been talking about here, the Conservation Commission, expressly found that Line 5 would be of benefit to all of the people of the state of Michigan and operate in furtherance of the public welfare. So the Attorney General's position is that, well, that's not a sufficient finding. And what we're saying is, well, there's nothing in Obrecht or Illinois Central that suggests otherwise, or that says that any other specific determination or finding had to be made. And all you have to do is take a look at the example statute. I mentioned this earlier, but if you go to our reply brief, it's Exhibit B. It's 1959 Public Act 84, and it's one of the statutes that the Michigan Supreme Court in Obrecht said is just fine in its view. And that dealt with conveyance of an easement for a bridge in Mackinac County, and the language of the statute granted authority for the issuance of the easement. And to the extent that it talked at all about protecting the public interest in navigable waters, it basically just instructed that before the conveyance is made, the Conservation Commission was authorized to consider whether, looking at the plans and specifications, alterations might need to be made in order to ensure that, for example, there wasn't an interruption in navigation. But I think if you look at that statute, and again, we attached it as an exhibit, you'll see that it doesn't contain anywhere close to the kinds of specific wording that the Attorney General is saying is required in this case. And I think if you look at what the Conservation Commission said, I think if you look at the Michigan Court of Claims opinion, fully appreciating that it was not specifically an issue. The court did not, we're not suggesting that the court made a finding that the statement in the easement is sufficient, but the Court of Claims was equally puzzled clearly by the Attorney General's suggestion that by using the words public welfare, that was somehow not a sufficient determination that there would not be harm to the public trust in granting the easement. So the fact that the Court of Claims didn't grasp what the Attorney General is saying here, I think is pretty telling. So the last thing I wanted to mention, and again, I come back to, we've talked a bit about this idea that, sort of what was required before Obrecht, what was required, after Obrecht. What we're trying to say is simply this, is it's a remarkable proposition to suggest that what the Supreme Court did in the Obrecht decision was to say that it's appropriate for a court to go back and look at conveyances, look at statutes, and, parse them and pick them apart to determine whether the proper words were used. Okay, the court specifically referenced the idea of previous legislation, and I won't belabor that point, but we've talked about how not just the 1953 Act that gave rise to the grant of the easement here, but the 1959 statute that the court blessed and that didn't contain the kinds of specific wording that the Attorney General says are required. I think that should tell you a lot about how realistic it is for the Attorney General to come into court and say you need to invalidate an easement that was duly granted under specific authority granted by the Michigan legislature because it didn't contain sufficient wording in the Attorney General's view. When you layer on top of that the fact that the Attorney General's office signed off on the easement 70 years ago, and nobody has questioned the validity of that easement until the Attorney General's lawsuit in this case. And so with that, I think everything else has been covered. We talked about the Lakehead pipeline case. I think if you look at that case, the Obrecht case talked about alienating property for a purely private use. It used the words private use. The point of the Lakehead case is to recognize that when Line 5 was granted the easement to be placed on the Straits bottomlands, the court recognized in the Lakehead case that wasn't just for the private economic benefit of Enbridge's predecessor. Certainly recognized that there would be benefit, but the focal point was on the fact that putting the pipeline in was a public use, that it would benefit the public. And so I think that to suggest that that there's something, and part of the public trust doctrine, of course, recognizes commerce. I mean, commerce is part of what is under the umbrella of the public trust doctrine. So to suggest that a determination that Line 5 is a public use somehow that's not relevant to any sort of public trust determination, I think doesn't give the Lakehead case the due that it should receive. And so with that, I think that's everything I wanted to say on the Attorney General's motion. So I thank you for your time.
Thank you. Mr. Bach?
Yeah, thank you, Your Honor. Just a few quick points. And I'm just going to kind of begin at the beginning and go in chronological order, at least according to my notes. In his arguments about distinguishing this case from the Bad River Band case, Mr. DeRosier made a few points that I'd like to respond to. First and foremost, he stressed that that court did not order that Line 5 be shut down or rerouted immediately. He set it out 3 years. And I'm just going to point out to the court that in the Attorney General's complaint, she seeks essentially 2 categories of relief, really 3. The first is declaratory relief, which we've asked for in this motion. The second is a permanent injunction requiring Enbridge to decommission the portion of Line 5 located in the Straits of Mackinac. And the third is any such other and further relief the court deems appropriate. But as to that permanent injunction sought in the complaint, the Attorney General is very clear in the complaint that it should be after a reasonable time. Nobody's arguing for an immediate shutdown of the pipeline. And I just wanted to make that clear. In particular, I also want to make clear, as the court's well aware, there have been these 2 major anchor strikes that have damaged Line 5. And so the Attorney General is asking in this case for a permanent injunction requiring the removal of the Straits pipelines from the Straits of Mackinac after a reasonable time so that markets can adjust, people can make preparations. And the Attorney General looks forward to putting on factual evidence about that at the next remedy phase. But that is, again, not an issue before the court today. Mr. DeRosier also categorized, referring to the Department of Justice or the United States amicus brief in the Bad River Band appeal. He said that the United States agrees with Enbridge that the district court's decision goes too far and does not take into consideration the treaty. And that is a very overly broad characterization of what the Department of Justice argued in its amicus brief. The Department of Justice agreed, expressly acknowledged that the trial court that Enbridge was in trespass, it needed a valid easement to have its pipeline located on the band's property, and that the treaty did not preempt that. What the United States argued was that the district court should have considered as one of the equitable factors in balancing whether to enter injunctive relief, whether there might be some harm to the public if Canada initiates international arbitration with the United States in response to a shutdown and Canada prevails. That, again, is a fine thing for this court to consider at the next phase of the case. But it has nothing to do with I want to make clear the United States absolutely did not argue that the district court did not consider the preemptive effect of the treaty or that the treaty would have any impact on the stage we're in currently right now. Like we've said, if the court rules in the Attorney General's favor on her motion today, which we believe the court should, then the next phase would be for the court to consider what is the appropriate remedy, and the court would balance the 4-factor test for injunctive relief. And that could include consideration of whether there might be some harm to the United States through international arbitration. But I just want to make clear that I believe respectfully, Mr. DeRosier was very overbroad in his description of what the United States position was there. Next, just in response to some points Mr. DeRosier made, I want to point out a theme for the court here. Mr. DeRosier said earlier in describing the Bad River Band case that it is not instructive because there was no easement there, and there is an easement here, okay? But in the Bad River Band case, Enbridge argued that it had a right to operate Line 5 on the band's reservation because the band's claims were preempted, just like it's arguing here. It lost those arguments, which are analogous to the arguments it's making here, and so now it attempts to sort of distinguish that case by saying, well, of course, these issues weren't present. No, the same issues were present, or very, very similar issues were present. Enbridge just lost on them, as it should lose on them here. Similarly, in the Davis case, which Mr. DeRosier mentioned in his response just now, in that case, Enbridge absolutely argued, along with the other defendants, that the Pipeline Safety Act preempted the nuisance and Michigan environmental protection statute claims that were in that case. It lost those arguments, and now Enbridge has attempted to distinguish that case by arguing that those issues were the issues that are before this court today were not present there. But they were just decided in a way that aligns with the Attorney General's position and contradicts Enbridge's position here. Similarly, just now in his response, Mr. DeRozier's treatment of the Williams case, at least perhaps my notes are incorrect, but I heard it significantly different from how he described it earlier today before we took a break. Earlier today, he held out Williams as an example that injunctive relief is not available under the Pipeline Safety Act. And now he's acknowledged that no, it was a case where the court considered whether to impose injunctive relief, for nuisance, and decided not to. So there's just I'm simply pointing out a theme that Enbridge makes the same arguments in multiple different cases, and when it loses, it then attempts to distinguish those cases when actually those are instructive cases where those same issues were decided against Enbridge. Also, just now, Mr. DeRozier referenced the Couser case, which is it's COUSER, that's addressed in the briefs, as a case where he said that it stands for the proposition that once a routing and location decision is made, the PHMSA regulations dictate. And that is not, in my view, an accurate description of Couser. What happened in Couser was there was a pre-existing interstate hazardous liquids pipeline, which was regulated under the old Hazardous Liquid Pipeline Safety Act, which was the predecessor to the current Pipeline Safety Act. And the state there sought to impose a state pipeline safety permitting regime on an already existing pipeline. And the court held you can't do that, it's preempted. That was a clear attempt to impose pipeline safety standards. And this harkens back to what I said earlier. Every one of the cases that Enbridge relies upon, except for Williams, which I'll reiterate in a moment, every one of them involves a situation where a state was attempting clearly to impose pipeline safety standards as that term is defined in the Pipeline Safety Act. They said you need a state pipeline safety permit. We're going to have state pipeline safety testing requirements, public meetings. You have to submit to our review of your pipeline safety measures. That's the same with Olympic Pipeline. It's the same with all of the cases that Enbridge relies upon. And the Attorney General agrees that where a state attempts to impose actual pipeline safety standards, they're preempted. But that leads the court to the crux of the issue. Is the public's right to fish, swim, navigate, and its ownership of the Great Lakes and their submerged lands an oil pipeline safety standard? Framed that way, it's very apparent the answer is no. And so it isn't preempted. Is the common law of public nuisance a pipeline safety standard? An action under nuisance, I would say, could be a pipeline safety standard if we held that the court should enter an injunction requiring Enbridge to satisfy a number of state pipeline safety requirements. But that is not what's happening here. And so it's not a pipeline safety standard. Is the Michigan Environmental Protection Act a pipeline safety standard? Clearly not. We've cited the Nemeth case and the Her Majesty the Queen case that held that MEPA does not impose any standards. And so there's a clear distinction there. And so Mr. DeRozier referenced Couser just now, and I just want to make clear that, yeah, that's a case. The holding there was not at all that location and routing decisions are made by the state the first time, and then subsequently the PHMSA regulations take over. The holding of Couser was that the state could not impose a state pipeline safety permitting requirement on an interstate oil pipeline. Now, Mr. DeRozier was talking about Illinois Central and Obrecht, and he said that they have no specific requirement of specific verbiage. But that is not true. In Illinois Central, and I apologize, I don't have the exact pin site, but we do provide it in our recent supplemental briefing. In Illinois Central, the U.S. Supreme Court expressly said there are one of two due findings that have to be made, and it was that the public's rights will either be enhanced or at least not impaired by the proposed conveyance. And so that verbiage is specific. There's a place it came from. It came from the U.S. Supreme Court decision in Illinois Central. And those are the requirements. We've cited this in our briefs, but the legislature codified those into the Great Lakes Submerged Lands Act, which is now Part 325 of the NARIPA, in 1955. And so that those specific findings are required, and there is no authority to support the notion that other findings can be substituted. Indeed, quite the contrary. The U.S. Supreme Court, and the Michigan Supreme Court has adopted this, has held that absent those specific findings, the conveyance is not valid. There's, what Enbridge is arguing for in this case is for the court to effectively create an alternate path by which a state can convey away the people's rights in their Great Lakes and their submerged bottomlands, which is to make other findings, right? Or Enbridge has asserted estoppel, prescriptive easement, to make a conveyance without the required findings, and then just allow enough time to pass, and it somehow becomes valid. But that is not the law, and it's not what the U.S. Supreme Court did in Illinois Central, where the conveyance was decades old at that time. I want to briefly address two other things that Mr. DeRosier brought up, and then I'll be concluded here. With this, Mr. DeRosier referenced this public act from, I think it was 1959. Yes, 1959, relating to a bridge in Mackinac County. And he pointed out that this public act does not contain those findings. But there's a couple of problems with that. I mean, first and foremost, there was no issue before the court today as to whether that public act was valid. But second, in 1955, Michigan passed the Great Lakes Submerged Lands Act, which is now, as I mentioned, codified at Part 325 of the Natural Resources and Environmental Protection Act. Beginning in 1955, that statute created a specific process where permits or leases to Great Lakes submerged lands could be acquired from what is now EGLE. At the time, it would have been, I believe, the Michigan Conservation Commission. And that statute expressly requires that those findings be made. And so it is no longer the case. There's an intervening event between the 1953 easement and between this 1959 public act. In 1955, the legislature created an alternate path whereby people could get permission from the state and satisfy that due findings requirement. And indeed, that's the reason why there haven't been more of these cases since 1955, is because in 55, the legislature delegated that decision to the appropriate state governmental agency to handle the leasing and permitting related to Great Lakes submerged lands. And indeed, in the legislative history, that statute was passed because it was 1953 and 1954 that we had Line 5 and the Mackinac Bridge essentially created in the Straits of Mackinac, and that caused the legislature to turn its attention to the need for uniform regulation of this. And so that's why there haven't been more of these cases since 55, is that, that was when the state developed a specific administrative procedure to address it. Finally, I've already addressed earlier Mr. DeRosier's comments about the Court of Claims statements in I think it was a 2018 case where that was pure dicta, and the court expressly held that that issue was not before the court, the validity of the 1953 easement, and so that should be given no weight. And finally, the last thing I want to address, Mr. DeRosier spoke about the Lakehead Pipeline Company versus Dane, D-E-H-N case from 1954, where he states, and the Supreme Court did say this, that Line 5 constituted a public use. And I want to address that because we've addressed it in our prior briefing from 2020, and again in our supplemental response on December 16th. But I just need to point out, that was a condemnation case. The court, is probably well aware, but when condemning, the Constitution allows the state government and the federal government and county and local governments to condemn land, essentially using the eminent domain power to take private land for a public purpose or a public use. The Lakehead case involved the condemnation of privately owned upland. It wasn't anything in a lake. It wasn't Great Lakes submerged bottomlands. There were no public trust issues. But privately owned upland was condemned for the Line 5 right-of-way when Line 5 was laid across people's property. And of course, it would require payment of just compensation. But so as the court may be aware, anytime that happens, there's a question: when land is being condemned, it has to be for a public use. And when it's being condemned for a use that is created by a private party, there's a specific test under condemnation law that the Michigan courts apply. And we've cited in our briefs that that test has changed multiple times over the decades. But the point is that the question in Lakehead was not whether Line 5 was a conveyance to a public entity for the purposes of the public trust doctrine. The question in Lakehead was simply whether Line 5 constituted a public use for the purposes of condemnation. And there was actually a pipeline condemnation statute that was in effect at the time that said, here's how you determine if condemnation for a privately owned pipeline is a public use for the purposes of condemnation law. And interestingly, we cited this in our brief. It says that you apply the same test that you do for condemnation of railroad rights of way. Okay. The reason I bring that up is because in Illinois Central, the conveyance that was revoked for not making the due findings was a conveyance of a railroad right of way. It was a conveyance of Great Lakes submerged lands to a railroad company, which is a classic, quote unquote, public use under condemnation law. But for the purposes of the public trust doctrine, what the U.S. Supreme Court said was it referred to any alienation of Great Lakes submerged lands to a private party. That is clearly different, right? That's what happened here. Here, Great Lakes submerged lands were conveyed, or an interest in those lands was conveyed to Enbridge, a private party. That whether that conveyance satisfies the public trust is a completely different requirement than whether it is considered a public use for the purpose of condemnation law. And I think in Illinois Central, the U.S. Supreme Court invalidated a conveyance to a railroad company for railroad rights of way, which is the classic example of a public use under condemnation law. Indeed, Michigan's pipeline statute, which Lakehead references, says when considering whether a pipeline is a public use, you apply the same test you use for railroads. That can be a public use under condemnation law. It's still a conveyance to a private party of Great Lakes submerged lands under the public trust doctrine. And therefore, as the Supreme Court held in Illinois Central, it is an invalid conveyance absent those specific findings. With that, Your Honor, that's all I have in response to Mr. DeRosier. And as Mr. DeRosier did, I thank the court for your time today.
Mr. DeRosier, are you all set, sir?
Your Honor, if I might just have just a couple of minutes, I appreciate the opportunity just to kind of wrap up. I feel like we've had kind of a lot of back and forth, and it would be nice. And we're Mr. Bach's kind of retreading stuff from earlier this morning, which I don't intend to do, but there was a lot covered just now, and I just wanted to touch on a couple of things, if I could indulge, if you could indulge
That's okay.
me.
That's okay. Just like we did before with Mr. Bach, I will allow that, and then we'll hopefully be able to wrap up, as you say, in sort of summary fashion as to where you each are with your arguments. Go ahead, Mr. DeRosier.
Thank you, Your Honor. So there are a couple things I just wanted to mention. One, going back to Bad River very briefly, I know that Mr. Bach kind of keeps repeating the refrain that the trespass claim there, which isn't alleged here, is the same or at least very similar. But it absolutely is not even remotely close to the same. There, Enbridge had an easement and the easement expired. Enbridge made an argument that the easement should have been renewed and that it was a breach of an agreement with the tribe when the tribe refused to renew the easement. But that's a much different situation than what we have here. And I'm not going to, I don't want to go over and retread everything that I've said before about that issue, but there is no trespass claim here. And I think if you look at what was involved in Bad River, it's not remotely close to here. And then I also just, again, reiterate, all of this is on appeal, including the whether any shutdown order, frankly, is appropriate, is all before the Seventh Circuit. Moving on to, again, I feel like we've been talking about Williams a lot. And I feel like anytime I mention what I think about it, I end up having to address it again. But I guess I want to try one more time that the thing about Williams is we're not saying that injunction. The important thing, when it comes to the Pipeline Safety Act and what relief can be granted, it's if you are seeking injunctive relief because of an attempt to enforce safety standards, which, as we've been talking about at length today, we think that's exactly what the Attorney General is doing with all of her claims. That is what Williams said is preempted. It's not the Williams court didn't just evaluate whether the injunction was appropriate or not under the factors. The Williams court said that the request for the injunction was preempted because it was an effort to impose safety standards. So in that sense, we contend that the case is absolutely worth looking at for that purpose. And then I guess I want to just really wrap up, kind of coming back to, again, what does OBREC require? What does Illinois Central require? And I think that the more I hear Mr. Bach talk about it, and this goes all the way back to the complaint, to the briefs, the claim that the Attorney General is making is that the Conservation Commission didn't use the right words. They didn't use the magic words. And I know the Attorney General doesn't like when we say that, but that's what their claim is. It's formulaic, it's formalistic, it is putting form over substance. If you look at what the Conservation Commission said, it is no different than the statute that we've been talking about, that the Supreme Court in OBREC blessed. And I know Mr. Bach was talking about how, well, you really have to take into account the fact that in 1955, you had the Submerged Lands Act, and that required additional steps. Well, the Supreme Court didn't address any of that. The Supreme Court said that the findings in the statute met whatever requirement it thought were met. And so again, we come back to, you have to ask yourself, in our view, it's not about is it about whether the right words were used, or is it about whether the Conservation Commission did determine in granting the easement that it was, whether you call it public welfare, public interest, did it protect the public trust? There are no specific words that need to be used. So we think that whatever OBREC required, the easement easily satisfies it. And that's everything I wanted to say. Appreciate you.
Thank you, Mr. DeRosier. Mr. Bach?
Yes, Your Honor, just very briefly. 3 quick points. First of all, with regard to the Bad River Band case, it is true that case involved a trespass claim, and this case, the Attorney General has not advanced a trespass claim. But that isn't the reason why Bad River Band is instructive here. The reason Bad River Band is instructive here is because both involved the question of whether federal law preempts a sovereign landowner from bringing common law actions to challenge Enbridge's ability to operate Line 5 on their land without a valid easement. We're at the summary disposition phase here. Enbridge is arguing that the Attorney General's case has to be dismissed because it fails to state a claim on which relief can be granted. This is a C8 motion. And I think the Bad River Band case and supported by the United States brief in the Seventh Circuit there, stand for the proposition that no, the Attorney General has stated a valid claim. Enbridge cannot have its pipeline on Michigan's submerged Great Lakes bottomlands without a valid easement to do so. And it cannot, and the Attorney General states a valid claim by bringing common law actions such as the public trust doctrine and public nuisance. I mean, the Bad River Band case also included a public nuisance claim, as the Attorney General's does here. And so, Enbridge is making these minor factual distinctions. Well, the band pled trespass, the Attorney General has not. But that's a distinction without a difference. The question before the court is, has the Attorney General stated a claim on which relief can be granted? And the answer is clearly yes, because the Bad River Band's case was allowed to go forward. And in fact, the Bad River Band prevailed. And so I think that's the value of Bad River. The fact that their claim was a trespass claim and the Attorney General's claim says you don't have a valid easement, completely a distinction without a difference. Mr. DeRosier's last point, asking about what do Illinois Central and OBREC require. And once again, he reiterated sort of the refrain that it comes down to a technical formalistic requirement and that it just didn't involve the magic words. And again, I have to push back on that for 2 reasons. I mean, first of all, this is not a technical formalistic requirement. It's an important requirement. It's a significant requirement, not that the magic words be said, but that the rights of the public in their public land, their submerged public trust Great Lakes bottomlands, have to be formally considered and formal findings have to be made. And that was not done here. That is not saying the magic words. It's considering certain issues that are expressly spelled out by the U.S. Supreme Court in the Illinois Central case, and that are now required in Michigan under a statute and have been since 1955, but were required by the common law in 1953. Moreover, I just need to quickly make the point that words matter. The fact that, you know, Enbridge is sort of trying to sweep this away as saying it's just words. It's just magic words. Well, first of all, it's not. It's a formal, duly recorded finding that has to be made. That was not made. It's an issue that was not considered. But also, when the Supreme Court says these are the findings you have to make, those words from that case law matter. The public's rights matter. They're significant. And they were not made here. And this isn't some formalistic technical, not a technicality. It's an important requirement that arises from or from the United States Constitution, and has existed in Michigan law since it became a state. And so the fact that it was not made here necessarily invalidates that easement. And that's all I have to say, Your Honor, unless the court has any further questions for me.
So on that point, Mr. Bach, is the only thing I'm to look at are the words in the easement? In other words, and I'm taking into consideration your argument regarding C8 and whether or not there is a statement of a claim on which relief can be granted. Are you saying that there may be more through discovery? There could be more presentation as to what it is that the commission either did or did not look at or do, or are we limited to what the document itself says?
No, Your Honor, we're limited to the findings have to be formal and duly recorded. And so we're limited to what's in the record here. There is no discovery that could unearth the fact that there is this document out there somewhere that nobody found. It would have to be either in the public act or in the easement itself. Since
not in some other public record, for example.
Correct, Your Honor, is as far as I'm aware. And further, we would assert that there is no other such record. These are the places it would be. And I dare say we've looked, and I'm sure Enbridge has looked, and there's no amount of discovery that could change that fact. Since 1955, those findings based on the Great Lakes Submerged Lands Act would be made as a matter of course in every easement or permit or any other conveyance of an interest in Great Lakes submerged lands. But prior to that, and sometimes even subsequently, they were included in either the easements or the enabling statutes themselves, but they were not included here. And so there is no possibility that discovery could yield some other
commission notes or something like that.
That's correct, Your Honor. And even the findings have to be formally made and duly recorded, which means if a commissioner jotted in their notes that they thought these findings were satisfied,
They would still have to be moved to something formal.
Yes, Your Honor.
Okay, well, no shock to either of you, but I'm going to take this under advisement and issue an opinion, a written opinion on it. So if there is nothing further either side wants to present, we will wrap this up. Mr. Bach?
Nothing further, Your Honor. Thank you very much for the court's time today and the staff's time as well, Ms. Warner and Ms. Smith. Much appreciated.
Mr. DeRocher?
I extend those same thanks. We really appreciate the opportunity to be here. And I think we've covered everything that we need to. And obviously there's a lot of briefing. So
yeah, the briefing was excellent, by the way. So you're correct. A lot is covered in the briefing.
So we do appreciate your time today.
Right. Thank you both. That concludes this hearing.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome.